Faites l'appel, s'il vous plaît, Madame le greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brelade.
Présent.
Monsieur le connétable de la Trinité. Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présente.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément.
Présent.
Monsieur le connétable de Gruville.
Présent.
Monsieur le connétable de Saint-Ouen. Monsieur le connétable de Saint-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le député Southern. Madame le député Labbé. Monsieur le député Tadier. Monsieur le député Luce. Madame le député Dublay.
Présente.
Monsieur le député Morel.
Présent.
Madame le député Lehegara. Monsieur le député Ayer. Monsieur le député Ward.
Présent.
Madame le député Alves.
Présente.
Madame le député Gardner. Monsieur le député Gorst.
Présent.
Monsieur le député Farnham.
Présent.
Madame le député Moore.
Présente.
Monsieur le député Mézet. Monsieur le député Balash. Monsieur le député Coles. Madame le député Poré.
Présente.
Monsieur le député Ward.
Présent.
Madame le député Miles.
Présente.
Madame le député Scott.
Présente.
Monsieur le député Renouf. Madame le député Curtis. Madame le député Falcon.
Présente.
Madame le député Binet.
Présente.
Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howell.
Présente.
Monsieur le député Binet. Monsieur le député Ferry.
Présent.
Madame le député Kovac. Monsieur le député Curtis. Madame le député Ward.
Présente.
Madame le député Wilson.
Présente.
Madame le député Stevenson.
Présente.
Monsieur le député Andrews.
Monsieur le doyen.
Notre aide soit au nom de Dieu qui a fait les cieux et la terre. Amen. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre pour le règlement et pour la conduite du peuple, et qui nous a commandé d'avoir toujours pour but la gloire de ton saint nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de prudence, d'unir les cœurs et les affections de tous ceux qui la composent, de la conduire tellement toi-même par ton Saint-Esprit, que toute l'heure de libération est en accompagnée de ta bénédiction. Réussisse au bien-être et au surgissement du peuple, qu'il te plut de commettre à leurs soins. Car nous t'en prions au nom et par les mérites de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné de t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite sur la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonne nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Et ne nous envoie pas en tentation, mais délivre-nous du mal. Car à toi, la reine, la puissance et la gloire, au siècle des siècles. Amen.
Monsieur le député Southern. Madame le député Labbé.
So Deputy Labadie is out of the Island Bond States business. I ask that she be marked accordingly.
State's business.
Madame le député Kovac.
Malade.
Vous jurez que Madame le député Kovac est tellement indisposée qu'elle ne peut pas assister aux états sans exposer sa santé.
Malade. Les états sont constitués. Joining us this morning in the gallery is the Chief Minister of Guernsey. I think I speak for all of us when I say the two bailiwicks are strongest when we work together, and we're delighted to welcome you to the Chamber this morning. We now return to the order paper and the continuation of the debate on the draft termination of pregnancy law. And the next speaker is the Connétable of St Brelade. Connétable.
Thank you, sir. And I speak to relay a communication from one of my parishioners who was particularly concerned about this proposition. I bow to the superior knowledge of the ladies present in the chamber, so the views are that of my constituent rather than my own, but I think they need to be addressed by the rapporteur when she comes to summing up. I mean, the first point that is made is that the consultation process was flawed and biased, and the government paid only attention to one organisation, BPAS, which is an extreme pro-abortion campaigner and a major abortion provider, to report on provision. Moving on, sir, it's pointed out that it was the proposals, legislative proposals, are extreme and unpopular. The abortion on request up to 21 weeks and 6 days is described as one of the most extreme abortion laws in the world and was supported by less than half of the public consultation respondents. There was a complete omission of risks to women's health. The consultation and drafting process had completely overlooked the documented dangers of abortion to women's physical and mental health. BPAS denies these risks. There was a neglect of fetal rights and welfare. The rights and welfare of the unborn child are unprotected until the moving point of viability. So in summary, sir, I was asked that the current proposition lacks proper democratic process and consideration of scientific evidence. So I just ask the rapporteur, when she sums up, to comment on those points. Thank you, sir.
Thank you, Connétable. Deputy Moore.
Thank you, sir. First, before speaking, I would like to ask a question of the Attorney General. I gave him notice last night of that because it pays a material difference to... he doesn't seem to have received my email from his look, but I will ask him a question if I may. My question relates to whether or not it's best placed to make my point at this stage in the principles or during the articles, because my point relates to the cost and why this is a paid-for service versus a free service, such as the newly agreed assisted dying service. So the question to the Attorney General is whether the contents of Article 17, which relates to fee orders, could be, what would the impact be if members voted against that? Because in my reading, it's such a broad article that there would not really be any purpose in voting against that. And so I think really the point ought to be made in the principles. But if the Attorney has a view, I'd be grateful.
Mr. Attorney.
Well, the effect of not adopting Article 17 would mean that there would be, it would remove the proposed power for the Minister by order to provide for fees to be charged for termination services, termination-related services, counselling services provided in connection with termination services. It would remove from the legislation the power to make orders to set fees for some or all of the services, set different fees for different services, to provide exemptions from fee payments, including how exemptions are applied. So one can see what the effect would be by reading the terms of Article 17, which would no longer be there. I hope that's helpful.
I think that is helpful. Thank you very much, Mr. Attorney. So my understanding is that if we vote against Article 17, when we get to the articles, we would remove the ability of the Minister to charge a fee for this service. And so would ask when we get to that point that we debate that article separately. But at this point in the principles, I would ask the Assistant Minister if she could, when summing up, explain to the Assembly why this service in particular is going to be a paid-for service, as opposed to, as I said, when posing my question to the Attorney-General, the assisted dying service that members have agreed will be a free service to those who wish to use it. Thank you, sir.
Thank you, Deputy.
May I ask the Attorney-General something?
Yes, you may.
It may not be, it may just be a logical answer, but setting fees could be set at 0. Is that correct?
Mr. Attorney.
Well, 0 is not a fee, I think.
My point being, sir, that if that stays there, if the Minister decides that the fees would be 0, that is consistent with the law.
Yes, the provision is permissive, not mandatory. The Minister may, by order.
Thank you, Mr. Attorney. Does anyone else wish to speak on the principles? Deputy Stevenson.
Thank you, sir. And I want to start by thanking the Minister and their officers for their work on this legislation, which I know has been a challenging piece of work at times, not least due to the issues with resourcing around it, but of course because it's complex and it's a very sensitive subject matter. I would also congratulate the Assistant Minister on her speech yesterday, setting it out, because it set a really clear tone for this debate as well. And I would also like to touch on the contribution from Deputy Miles yesterday, because I think that was a really important one, and I hope it made others in the Assembly and outside as well actually stop to think about the support we provide to families who have children with disabilities, because it certainly did make me stop and think. But I'm pleased where we've got to where we are today with this, because islanders, and in this case women in particular, although it's not just a women's issue, it may be happening to a woman's body, but there are two people in these situations as well. So I think although it is very, very relevant to the lives of women, we should not just categorise it as something for women or something for the women in this assembly to be thinking about. Islanders deserve modern, up-to-date and fit-for-purpose laws, and the existing termination of pregnancy law, as we've already heard, is from 1997. But as the Minister's report accompanying the proposition states, even then, much of what it contained was considered to be outdated, even when it was brought in, because it was based on the UK's 1967 law. And in 1967, Twiggy was dominating the catwalk. Miniskirts were in fashion. A woman ran the Boston Marathon for the first time. But it would be still 6 years before women gained access to the London Stock Exchange. In 1967, women still often required a signature from a husband or a father to open a bank account, obtain a mortgage, or secure credit. Equal pay legislation didn't exist, and women were frequently barred from senior positions and paid significantly less than men for doing the same job. Some bars and pubs still legally refused to serve women unless they were accompanied by a man. Juries were still largely male. There was no women's refuge anywhere in the UK. And fittingly, given some of the other debates we've had this week, under UK law in 1967, it was legal for a man to rape his wife. Thankfully, the world's moved on, and much of our legislation has too. And it's now time that our termination of pregnancy law caught up as well. There's a couple of specific points I want to make, and the first relates to the public consultation which informed this work, and why I believe it's vital that we take action following that work and the second consultation which followed it. And I think particularly with an election coming up, when candidates make all sorts of promises about listening to islanders, I think it's even more important that we reflect on the use of public consultations and what we do with the views and the feedback that islanders provide us with. In this case, a public consultation took place between July and October 2023, and there was a second phase last year. And I'm sure that the Assistant Minister will touch on the points made by the Connétable of St Brelard, but I would draw members' attention to a Freedom of Information request that is published online, where somebody asked about exactly the points that he made. And it does state very clearly, and the report on the consultation itself makes this very clear. So there's no attempt to hide any links there. But the initial interviews conducted with women who have experience of termination in Jersey were carried out by the Centre for Reproductive Research and Communication. And the FOI states it is recognised that it is situated within BPAS, the British Pregnancy Advisory Service, which has a clearly stated public commitment to protecting and extending women's reproductive rights and choices. And it goes on, and that's online for members to read if they want to, and members of the public. I think the thing I would just add there, it's the consultation, I think as the Assistant Minister said, it didn't start from a point of asking if abortion should be legal. It already is legal. It started from a point of asking people for their experience of lived experience and what they thought should be done differently. So the first consultation highlighted the absolute need for change. The second provided more detail on what people thought those changes should look like. And I think it's really important that we close the feedback loop when we're asking people for their views, and that, particularly where it's about something such a sensitive topic and we're asking for people's personal experiences. It's closing that feedback loop is vital for trust and public engagement. And you close that loop by providing thanks and feedback and publishing results, and by explaining clearly what happens next. But by far the most powerful way to close the loop is to take action based on and informed by that public consultation. And people are much more likely to take part in public consultations in future if they see how their contributions are helping to influence policy and decision making. And that's exactly what we're doing here today as well. Another aspect of this proposed new law I'd just like to comment on, and it's not in the 1997 law, but is a welcome addition, is the ability of the Minister to use regulations to designate an area around a termination clinic as a safe access zone. In those areas, certain activities would be banned, such as intimidation, harassment, or obstruction. Obviously, we'd hope it would never be needed, but there are examples around the world that show it is important that we have that provision should it be needed. I would like to ask the Minister if that regulation, if there is capacity for that regulation to be extended to fertility clinics in future, should it ever be needed in Jersey, or if consideration could be given to that in future. Because increasingly in countries such as the United States, we are seeing anti-abortion campaigners that are targeting fertility clinics and IVF procedures. Since the overturning of Roe versus Wade and subsequent concerning developments in the US, there are some who now categorise embryos as children, their view being that life begins at fertilisation. And that position could, and in some place is, impacting on fertility treatment and patients. And it does, for those individuals, it's raising questions about the storage, testing, and particularly in this context, the discarding of unused embryos, which some campaigners are now categorising as abortion. Now, we don't have embryos currently stored or transferred in Jersey, but the people who are receiving treatment are here and receive pre- and post-embryo creation treatment locally. Again, we hope that that kind of intimidation would never happen here, and the risks will be very low, but it can't be ruled out. And I'd like fertility patients to know that their government has their back should it ever be needed. I think the Minister has covered quite clearly the service limitations and set that out kind of unapologetically as well. And I think that's important. The proposition doesn't shy away from explaining that that proposal does not automatically expand service provision. Of course, in an ideal world, I don't want women to have to travel for such procedures, and it does come with extra costs to them. But it really doesn't mean we shouldn't support this law today, or that it will necessarily lead to new pressures on resourcing and funding to provide such services. Because the reality is, as the Assistant Minister set out, even in the UK, people often have to travel to specialist clinics for later stage terminations. And I acknowledge that Jersey is a small jurisdiction and this is a specialised procedure. Changing the law as proposed without a guarantee that service provision will be extended will still have positive benefits. It will reduce stigma associated with such decisions. And that's a really important point. This is back to the people going through this experience. It will reduce stigma for them. It will give clinicians clearer guidance within which to work, and it will allow greater flexibility through future regulations and orders. Finally, sir, I want to comment on the 22-week limit in the law, as I think my panel chair, Deputy Doublé, did yesterday. And I want to thank Deputy Hilary Jern for bringing this to our attention. And Deputy Jern has given me her permission to say that as well. In future, I would like us to consider a carve-out in the law which would allow a person who's had a potentially serious medical issue identified at their anomaly scan, typically at 20 weeks, time to make an informed and settled decision without being rushed by the 22-week deadline. In reality, the deadline is 21 weeks and 6 days, and if you consider the timings about when scans take place, so you could be 20 weeks and 3 days when you have your first scan, how many days does that really give them to digest the information, maybe seek counselling support, research possible outcomes, seek further tests or medical opinions? And all of that alongside trying to come to terms with what may be a diagnosis, discussing with partner, with families. Other jurisdictions, I believe, have such carve-outs, and actually places like the UK don't need it at all because they use the 24-week limit instead. And I want to just highlight a letter sent by 120 fetal medicine experts who are affiliated with the UK's Distinguished Royal College of Obstetricians and Gynecologists. And it was sent to MPs in May 2024 concerning abortion amendments tabled to the Criminal Justice Bill. And they were talking about exactly this situation, because some of the amendments were seeking to bring the 24-week limit down to 22. And the letter states, as medical professionals who care for patients who need later gestation abortions, we are alarmed that these amendments have been tabled to the Criminal Justice Bill. They would have a catastrophic impact on the care that we are legally allowed to provide our patients, as well as on women's ability to make decisions about their pregnancy. While the numbers of women affected is small, if passed, these amendments will deprive the most vulnerable and high-risk girls and women of access to essential and potentially life-saving healthcare. It will force other women to make a decision to end or continue a much-wanted pregnancy before the diagnostic pathway is completed. This goes against best practice guidance and basic medical care decision-making. And the letter explains that tests which may follow a diagnosis from an anomaly scan can fail to give definitive results or may need to be repeated. And this means that if the gestation limit was reduced to 22 weeks in the UK context, a woman will have passed the abortion time limit before she's even received a diagnosis, and will result in her having no time to come to terms with the diagnosis or to consider her options. And that letter is online and is able, I'm willing to send it round, or it's there for others to see. Conscious of time, but the same letter also highlights that 90% of abortions occur before 10 weeks, and those who do present at 22 to 24 weeks, who are not having an abortion due to fetal anomaly, are frequently very vulnerable. And it states, if their ability to access safe abortion care up to 24 weeks is removed, this can have a lasting detrimental impact and may even be life-threatening. It says that research shows that the common reasons, other than fetal anomaly, for needing an abortion at later gestations included domestic abuse, particularly abuse which has worsened during pregnancy, health problems of the woman herself, both mental and physical, a change in circumstances during pregnancy, such as the loss of a partner or a serious illness diagnosis for an existing child, late detection of pregnancy, often as a result of health conditions, young women under the age of 18 who may not have realised they were pregnant or concealed it through fear. And they conclude, reducing the abortion time limit from 24 weeks to 22 weeks will target these especially vulnerable women and girls, forcing them to continue with a pregnancy that they do not want, which can have a detrimental and lasting impact on their health, safety and well-being. No one would want to underestimate the difficulty in making a decision to end a pregnancy at such a late stage. However, forcing someone to continue an unplanned or unwanted pregnancy in these circumstances may put their life at risk. Sir, I think the law here today is a significant improvement on what exists already, but I do think it could be improved yet further, and I hope that this can be addressed in the not too distant future. I would be interested to hear from the Assistant Minister about why the 22-week limit was chosen rather than 24 weeks. She did explain in her opening about the viability concept, but in my research, it's not as clear-cut as perhaps she makes out. And did we ask in the consultation about 22 weeks, or 24 weeks, or just 22? Thank you, sir.
Thank you, Deputy. Deputy Tadia.
So there have been some excellent speeches so far. Deputy Stevenson highlighted the final speech that Deputy Miles gave yesterday, and I think that if we weren't already thinking along those lines, certainly it crystallised some of my thoughts, but also actually said some of the things that I would have wanted to say very eloquently about the difficulties and that this isn't completely a black and white area, especially when those comments related to disability, sir. My concern here, having read the comments and through the Minister's proposition, and can I also congratulate the Assistant Minister for proposing this yesterday in the way that she did, is that I'm mindful of the opening comments of the scrutiny panel, which says that the termination of pregnancy has been legal in Jersey since 1997, since the 1997 law. But they say that this law was already considered out of date at the time of its introduction, as it largely replicated the UK 1967 Abortion Act, which restricted access to termination based on limited prescriptive grounds such as distress. So my concern today is that we're proposing a termination of pregnancy law which is already out of date now, before we even adopt it. And I think Deputy Stevenson has started to take us through some of the reasons for that, and I will outline those concerns. I don't want us to get into a scenario, sir, where we're trying to replicate an A-level ethics class, sir, and so I hope that won't happen. What I would say, though, sir, is that the starting point, and Deputy Doublé touched on it in her comments when she was representing the panel's work, and I think her own thoughts on the issue around viability do need to be unpacked, I think. Because if the premise for this law is largely built on the concept of viability of the fetus or of the potential baby that is yet to be born, I think that is a highly problematic starting point for legislators. And I'll explain why. Deputy Stevenson did say that there are already those in the community who hold a view, which is absolutely their right to, that life begins at conception. Indeed, I know the 1001 days, which there are a lot of champions in this assembly. I think it was actually a policy of previous governments to support the 1001 days, which is the first 1001 days up until the age of 2. And if you do the maths, of course, 2 years, 2 times 365 doesn't give you 1001 days. That's because the first 1001 days also includes the period from conception. So clearly, pregnancy in itself, if you are going to have a baby and that baby's going to grow up, hopefully, into a young person and an adult, all of that 1001 days is an important period. On the other hand, we are left with the question of these arbitrary dates, which seem to be based on science, rather than necessarily the starting point being women's rights. And I think that's the nub of the issue here. So if, for example, a fetus were to be considered viable not at 22 or 24 weeks, but actually in the future at 5 weeks or even at 3 weeks. If it was possible in the Brave New World scenario to take that embryo or that fetus and actually say, you know, actually we can make sure this survives, what are the implications for that for future legislators and for women's rights? And so looking at this legislation, I think the major flaw here is that it hasn't started through the right end of the telescope. It started through, I would say, a pseudo-scientific starting point, which is probably actually largely being led by community pressure from the religious right, I would say, rather than actually from the starting point of what is best for women and what fundamentally supports women's autonomy over their own bodies. And if it had started from that point, I think it becomes a lot more straightforward to legislate for women's rights and control over their own bodies. Because it makes me very uncomfortable, and I hesitated as to whether to say this morning, because one does like to keep some things private. But I think I've mentioned in this assembly maybe before, and I've certainly written about the fact that my mother was relatively old when I was born, and she was 46 at the time. It's not entirely uncommon for that to happen, but it is fairly unusual. So I was an unplanned pregnancy. My mother was also deeply religious. She was a practicing Catholic. And she said to me after I was born that at the time there was quite a lot of pressure for her to have an abortion. I think she even said from the medical profession that people were saying to her, you know, Mrs. Tadia, you've got to be careful at your age. Your son might be severely disabled. And those words weren't used. If I were to repeat the words that some told her, it wouldn't be either parliamentary or acceptable these days. My mum made her choice, and she stuck by it, and I know what some members might be thinking. I hope not. And that's kind of stuck with me, because if we get into the argument about, and I listened very carefully to the panel's comments about this 23 plus 6, and there's quite I think, and I don't disagree with limits, by the way. I'm not saying that after 24 weeks. I think there do need to be limits. There are wider ethical considerations in all of this. But I think what we're doing here, actually, we're selling this law to us as if we're making great progress. But actually, it's behind what the UK is allowing at the moment. They have a 24-week limit, as I understand, and it's up to the woman to decide whether she wants a termination. I hope that's not an oversimplification. What we're doing is we're reducing that, so it's already a lower starting point, and we're saying after that point it has to be severe fetal anomaly. And then, of course, there's this question which has rightly been raised by Deputy Stevenson and the panel, saying, well, you know, there is this problem then if you get your 20-week scan and an anomaly comes back, but it's not a severe one, serious one that's going to affect the likelihood of the baby surviving or the health of the mother, then it becomes a matter of choice. And I think that then takes us into some very grey areas. I did read the comments that saying that there was a case that the UK court ruled on about the rights of disability groups, and that terminating, for example, an unborn baby with Down syndrome does not affect the rights of disability groups. So it's not an impingement on the human rights of disabled people. But I think it does lead to some very difficult questions that actually we shouldn't necessarily we don't need to ask as legislators. And I think, again, if it comes down to women's choice, because we know that there are so many reasons that women might choose to have a termination, and so many of those factors are not necessarily to do with internal considerations, but actually external ones, environmental ones. And I think this leads me on to the next point, is that I'm concerned that we're actually setting up a new law, but we're not actually setting up the commensurate provision in Jersey to be able to deal with that. And I want to read through a quote that the panel put in their comments from the Minister and I think from the Health Department. So I think it's just easier to read this part so I don't lose any context, and I'll try and do it as quickly as I can. The panel broadly supports these provisions but stresses that the on-island workforce is unlikely to be able to provide such procedures when the law comes into force. The proposition section acknowledges that Jersey's limited specialist workforce means later stage terminations, particularly those related to fetal anomaly, will continue to require travel to the UK with associated stress and trauma for women. This was discussed at the quarterly hearings, and the Minister and officer responded to the questions in the following way. So this is a direct quote. "We cannot force, you are referring to people in the hospital service being prepared to carry out terminations after a certain period, because I think that is the difficulty we're referring to. At the moment, we don't have the team of people who are prepared to do that. And I do not think it is reasonable, but we cannot insist that people undertake that work. If, over the course of time, through the recruitment process, people come on board that are able and are qualified and prepared to undertake that work, then that is a provision that would be available. But at this point in time, it's not something that people that are doing the work are prepared to offer. Then that work has to take place off island." That sounds remarkably cavalier and vague to me. It sounds like we're bringing in this new law. You know, there might not be people at the hospital who can do it because they're not trained, and they may not want to do it. And the consequence of that suggests to me that not just after the 22-week period, but actually a lot sooner than that, women are going to be forced to travel routinely off island for their terminations which are not free at the point of access anyway, which I think is wrong. But also there will be presumably an associated cost with that. And then the Minister goes on, "Sir, even in the event that we are not able to recruit a workforce that can choose and safely deliver terminations, it is nevertheless the case that amending the gestation limits does help remove some of the stigma that's associated with termination." So what we're hearing here is this is a great thing to do just from a theoretical point of view, but I'm interested in the practical implications of what we're going to see here. It is important because amending our law provides legal certainty for our clinicians in Jersey when they refer to the UK, and that is particularly important because at the moment in our law we have a 24-week limit for termination in the case of serious fetal anomaly. So if a serious fetal anomaly in Jersey was to be found at the moment, that woman was post 24 weeks and the clinician would wish to refer the woman to the UK, where she could, in their law, have a post-termination on the grounds of serious fetal anomaly. So my concern with this, sir, perhaps hasn't been mentioned yet, but we've spent the whole week debating, not the whole week, but we spent yesterday debating very important VAW legislation. Yet here we are debating ostensibly women's rights, and my point is that if a vulnerable woman who may be in an abusive and coercive relationship cannot have a procedure on island at whatever stage and for whatever reason, and is being referred to the UK, she may not be in a position to travel if she has a partner who is coercive and abusive. What does she do? Does she say, if you can get access on island, you can probably do that fairly furtively, can't you? You can go off to work, take some time out, your husband, your partner doesn't need to know where you are, and that can remain private. If you have to start booking travel to go to a clinic somewhere in the UK, you've then got to start telling your partner why you're going to be away. You may not even have financial control over your bank accounts. You may not have any economic financial independence. And I think this hasn't been thought through from a woman's point of view. I think it's been thought through from a fairly cold, clinical, scientific, but also from that ethical point of view where a lot of voices have come forward probably saying that don't even support a woman's right to termination in the first place. And I think that's why we've been left with a highly problematic law, sir. So we are in a difficult position here because I think we have to make a decision on what's before us. I certainly don't criticise the scrutiny panel because I think they've also been put in a position where this has been lodged towards the end of a term. And they've made recommendations, but had they had more time, I've no doubt that they would have put amendments in, and that we would have been able to consider this law in the light of some improving amendments. So I do find this, what's in front of us, problematic, not least, mostly actually, because of the practical implications that we're putting something in place. And I think if this was in any other sphere, if this was an education proposal that introduced theoretical rights but didn't actually give a practical recourse to those rights, or in any other domain, I think members would be looking at this and saying to the Minister, this isn't good enough.
Thank you, Deputy. Deputy Balash.
So I am a member of the Health and Social Security Scrutiny Panel, but I do not share all the views of the majority of that panel. The chair of the panel has put the argument, as indeed I think did Deputy Tadier, on bodily autonomy, the woman's right to choose, but that doesn't seem to me to be the whole of the story, because there are other human rights involved, namely the right of the embryonic child to life. Even for those who accept, in part at least, the bodily autonomy argument, there is a tension when it bumps up against the right to exist or the right to life. I am not well enough informed, sir, to state how close to viability is 22 weeks. But two things do seem to be clear to me. The first is that termination at an advanced stage of pregnancy is a difficult matter, both ethically and surgically. Secondly, the surgical difficulties are such that a termination cannot be performed in Jersey beyond, as I understand it, 12 weeks. All such terminations have to be performed in the United Kingdom. The reason for that is that the expertise for this kind of surgical procedure cannot be sustained by a practitioner based in Jersey, because the numbers are not sufficient to enable that expertise to be sustained. Any termination over 12 weeks, therefore, and I have this from one of the consultants at the General Hospital, is performed in the United Kingdom. So my question to the Assistant Minister when she attended upon the scrutiny panel was, what's the point of changing the law? To which the Assistant Minister's answer was, it's a question of stigma, which is the word that Deputy Tadier used as well. But I'm afraid I don't find that particularly persuasive. I must say that, in my view, of all the emotions that a woman in this situation might experience, the idea that the law in Jersey is different from the law in the United Kingdom and going to England involves some kind of stigma seems to me to be not valid. I think there is a logic to maintaining the period during which a termination can be performed in Jersey at the period which in practice it can be done. And for that reason, sir, although I support indeed a number of the other changes to the law which are brought about by this bill. Because I do not support the elongation of the period in question to 22 weeks, I'm not going to support this proposition.
Thank you, Deputy. Deputy Feltham.
Thank you, sir. Excuse me. I did want to give the Assembly some comfort as a member of the Women's Political Advisory Group that all of the considerations made by the Assistant Minister were taken and informed by the views of women. I switched my light on after Deputy Tadia's speech, actually, because he was suggesting that it was coming from elsewhere. This is very much something that we took very seriously. The Assistant Health Minister and I know the previous government have been working on this for some time, and consultation has been very important. I did take issue with some of the things that were said by the Constable of St Brelard that were questioning the integrity of that consultation. The consultation was robust, and that was despite attempts from off-island lobby groups seeking to influence what was happening here on this island. And it was really important that that consultation was robust in that way, and I wanted to give the Assembly the assurance from my point of view as a member of that group that the consultation was good. It did consider, obviously this is a matter of conscience, and the Women's Political Advisory Group as well was given very detailed information about the terms of pregnancy, the weeks, the different options that may be available to put into this this legislation that is ahead of us today. For me, searching my own conscience, the assessment of viability of life seemed to be the correct point for this piece of legislation. Other people may choose to take a different view. This is absolutely a matter of conscience. I listened carefully to the Constable of St Saviour yesterday and his view, and we spoke yesterday after the session. And I did share with him my view is that as science changes and viability of life changes, we need to be able to adapt our legislation accordingly as well, and I wanted to give him my assurance that as a member of the Women's Political Advisory Group, we had considered those matters. I would like to thank Deputy Miles for her speech yesterday, which I think was very powerful. I know that people, when they find that they may have a child with a disability, have to know that support is available for them, and it is really important that they are able to take decisions in the knowledge that they will be supported by our community. And I absolutely back up what she had to say there, and I'll do whatever I can in my role to ensure that that support is available. I also wanted to touch on what Deputy Stevenson said about support for the wider family as well, and the need for counselling, and I did want to seek assurance from the Assistant Health Minister that there will be support for wider family members, because this of course is not just a decision that is necessarily taken by one person or affects one person. It can affect a broader number of people. And I will share a personal story here, because I have visited personally a centre in Australia where terminations did take place. Not because of my own situation, and I hope that better care is provided now there and will be provided here. My situation was, I was in the situation where I'd had a miscarriage, and that was the only place where I could get the medication that was required, the similar medication that's used in early stage terminations. Reflecting on that visit, what I saw there were lots of different families and people there was a story to each of those situations. And what is really important to me about this legislation is that this is modernising legislation. It's about reducing stigma. It's about ensuring that people get the right level of care as early on in their pregnancy as possible, that they get the right medication and access to the right medical treatment. And as I said, counselling. There's a family and there's a person behind each one of these decisions, and I think it's really important that we remember that. So I do want to give assurance that from my perspective, I think we're coming to a good place with this legislation. Again, I want to give Deputy Tadier assurance this is based on modern legislation. Modern legislation is looking more at viability of life, and I think what we'd find is older legislations were the legislations that had the longer period of weeks in them, because as obviously science and facts change, we need to move in relation to that. We need to think about the medical professionals involved, as well as the impact on the families. So Sarah, I do urge everybody to support this piece of legislation. It's greatly needed. We need to modernise our outdated termination of pregnancy legislation. It has been informed by women's views, and I think that is very important.
Would the Minister take a point of clarification, sir?
Would you take a point of clarification?
Yes, sir.
Yes.
Would the Minister will her department be liaising with the Minister for Health to make sure that women, especially those who have terminations before 22 weeks, who need to travel are supported if they don't have the financial means? And would she also encourage the Minister to consider actually bringing doctors over to Jersey to perform terminations so that women don't necessarily have to travel to address those issues about coercion that I spoke about?
Deputy.
So yes, I am already in very active conversations with the Assistant Minister. She and I have worked very closely to ensure that people not only have access to termination services, but also contraception services as well. Something that we agree on is that access to contraception needs to be improved as well. So yes, absolutely, I would continue in those conversations and provide more practical and immediate help where that's appropriate. With regard to travelling doctors, I think that would be more of a medical, because obviously if it's an early stage termination, what we're talking about is effectively medication, so there's no need to travel off island there. I couldn't give any guarantee around whether it would be a good idea or not to have a doctor travel rather than the person seeking the termination, on the basis that I don't know if we'd have the effective equipment or anything like that. But at the very heart of this has to be putting people's well-being first. And so therefore, if that was the better thing for us to be doing, the most efficient and effective thing, and in the best interests of people, then I'd certainly be open to that.
Deputy Rob Wood.
Thank you, sir. And I think the previous speakers, I think Deputy Stevens, who mentioned a few things that I think are very poignant as well. And all of the speakers in one say, particularly the women speakers in this assembly who have spoken on this topic, and I thank them for that. Deputy Stevenson said that men are involved in this as well, yes, apart from the obvious, which we won't go into. But yes, they are. But there's a key point for me as a man, which is I do not understand the experience of carrying a child. I never will. I do not understand fully the experience of having to make that significant decision, and I never will. But what I have to be and what we have to be as men, and I've said this before and I'll say it again, I'm sure, are allies and supportive in that decision making. Yes, of course I can have a view, and in any relationship you would discuss and you would talk about the rights and wherewithals, but in the end it is a woman's right to choose. And I enter this debate from that simple position, that this is the woman's right to choose about her body and her future. And I think this law, it does update, and it does do so in the right way. I think it's important that we do that. I think we've talked a lot about stigma. I think stigma is very important in our society, actually, sir, and I would disagree. You know, again, my understanding of that experience would be limited because I cannot go through that experience. I cannot go through the experience of being the person who has to make that final decision. But I have to try as much as possible to empathise and understand. That's the important point of this. So I won't talk about Article 17 because that's for the article second reading, but I will talk about a principle that I have, and that is simple. Healthcare should be free at the point of need for everybody. And we are wealthy enough as a society to ensure that that can happen if we get our spend right and our taxation system right. And I believe that we should be supporting that. And yes, sir, I did bring the proposition to make travel off island paid for, and I stick by that because we need to as an island. It's a cost as an island. And I think it's important that we provide that support for anyone travelling to have treatment elsewhere, because we cannot provide everything on island, and we need to do so effectively and as sensitively as possible. So, but we'll come back to Article 17. I think you probably know what I would say about it, sir, because I've already asked the question of the Attorney General. But I just want to make sure that I make that point. There is an issue as we go forward about modern science and how we need to adapt to greater understanding, greater medical intervention, greater medical care, understandings of both genetics and in vitro treatments of you know, developing human beings. And so we need to be adaptive. This is the first part of adaptation of this law, I think, which brings it forward from 1967. I'll say to Deputy Stevenson to finish off, there was another significant event in 1967, sir, a very significant birth, but we won't go into who that was. And so, sir, I will urge members to support this proposition. I think it's the right thing to be doing at this time. Thank you, sir.
Thank you, Deputy. Deputy Miller.
Thank you, sir. I just wanted to address one of the comments that Deputy Taddy made, hopefully to assist the Assistant Minister, and I hope she doesn't think I'm standing on her toes, but I'm sure what I'm going to say is correct. Deputy Taddy was critical of the fact that at the moment in Jersey we do not have the specialists who can offer a late stage termination. And again, this is in the realms of counsel of perfection. Yes, it would be wonderful to have specialists who can do everything in the island, but we simply can't do that. And it's not just a question of money, because a medical specialist becomes a specialist by doing the procedure day in and day out, and continuing to do the procedure day in and day out. The last thing anybody would want would be to go under an anaesthetic and for the surgeon to get halfway through the procedure and then think, oh, I've forgotten what to do with this bit, or I'm not familiar with that, and oh, I haven't seen one looking at that before, and I'm to rush off and look at Google to find out what to do next. And even if we did recruit a specialist who could do late stage termination of pregnancy, these will, I'm sure we all hope, these will be very rare occurrences. And if someone came here in January, and if they're not called on to do the procedure by December, they are no longer a specialist. Medical treatments are, you can only rely on muscle memory so far. People have to be doing these treatments all the time to maintain their CPD and maintain their skills. And late stage termination is a highly technical, and this is from the discussions we had at the Women's Health Steering Group. Late stage termination is incredibly risky for the woman. It's a very difficult thing. It's not the same necessarily as a C-section. So it has to be done by a specialist. The Minister for Social Security have already said that they will work to make sure, I'm sure if there are vulnerable women who need to be helped to get away from the island, to have a very late stage termination, that support will be provided to them by whichever agencies may have to be involved. But it's not something that we can ever realistically promise to have a specialist on call. I agree with Deputy Taddy, that may be times, I think there could well be times where we could bring people, specialists to the island for periods of time. Whether you can do that on call, I don't know. But recruiting specialists is a challenging area because we just don't have the bodies and the frequency of procedure for people to maintain specialism. And I hadn't been going to speak, sir, apart from that, making that observation, but I spoke with a friend at the weekend about this, and I'm told that the availability of termination of pregnancy on a legal basis is really can be a critical factor for women's health across the board. And the example that I was given is that there are parts of America where termination is very much more restricted, where doctors are refusing to treat pregnant women for other conditions, including cancer, including where those cancers will become terminal if not treated. Even if the woman and her partner want that treatment, they will not provide it because they are frightened that it will induce a termination, it will reduce loss of the pregnancy, and that they will then be criminalised for inducing abortion. That is a dreadful state of affairs. So it is important that termination is available, not just for the reasons of the termination, but for women's health more generally. So I just ask people to reflect on that. Thank you, sir.
Thank you, Deputy. Deputy Renouf.
Thank you, sir. I hadn't planned to speak on this, and I think we've had some truly excellent speeches, particularly from Deputy Miles and Deputy Stevenson, which probably confirmed me in that decision. However, I was moved to stand because of the comments made by my fellow member of the Health and Social Security panel, and in particular Deputy Balash's view that the question of stigma is, I think I've got the phrase he used right, not valid. And all I would say about that is I think I would prefer to take a woman's view about the question of whether stigma is a valid argument in this circumstance. And I'd also add that it was pretty clear from my recollection of the reports that the stigma facing women is not, it's not just the question of the stigma facing women, it is the difficulties facing medical professionals who have to help women achieve termination in the UK when it is outside Jersey's legal limits. And I think those questions were legitimately raised. So I think on both those grounds, I would gently disagree with Deputy Balash and say that stigma is an issue. And I think that reason for changing the law is therefore valid. I do agree there are significant tensions within the law, and I think the Assistant Minister acknowledges this. The most significant tension for me is around the lack of provision in Jersey and the need for women or families to pay for an abortion because they have to travel to the UK. I accept that we will not provide in the island in the foreseeable future the kind of specialised service, but it is a cost barrier potentially, and that is troubling. It does mean that important decisions about health are being made partly in the shadow of a financial dimension. Although I accept that there are hardship grounds available, and therefore in the most extreme cases, hopefully that will not be a problem. But it is troubling that decisions on this issue will be partly determined by money. However, I do accept there is a pragmatic element here. It does make me wonder, though, when we consider all of these questions that have been in this debate, how these laws would have been framed right from the beginning if it were men who got pregnant. And we might think that they might have been designed in a slightly different way. But overall, I think this law is a pragmatic response to the situation in which we find ourselves in terms of the limitations of what can be provided in Ireland, limitations within the health budget. I do think that the issue raised by Deputy Stevenson concerning potential carve-outs beyond 22 weeks in situations of fetal abnormality scans should be looked at in the future. But in the meantime, I think the principles of this law are a welcome update, and therefore I will be supporting them.
Thank you, Deputy. Does anyone else wish to speak on the principles of the draft law? Constable St Lawrence.
Thank you, sir. I would just like to refer a question to the Attorney General, please, sir, because we haven't heard much mention really about the rights of the unborn child, the rights of the fetus. And on page 22 of the draft law, in the appendix to the report, we are given notes from the Law Officers Department, and we are told that they are for the information of states members. They are not and should not be taken as legal advice. But it does refer to Article 2 of the ECHR, the right to life, which says, the Convention states, everyone's right to life shall be protected by law. No one shall be deprived of his life intentionally, save in the execution of a sentence of a court following his conviction of a crime for which this penalty is provided by law. It then goes on, sir, to refer to some cases that have been considered by the ECHR, one in France, where the decision was that the unborn child is not regarded as a person directly protected by Article 2 of the Convention, and that if the unborn do have a right to life, it is implicitly limited by the mother's rights and interests. And I think really that has been the overriding theme during the speeches that we have heard over the past day and this morning. We are really considering the mother's rights and interests. But for what I would like to know from the Attorney General, sir, and I note that actually he did comment on this for the law officers when he was SG. There is another reference made to an application in the United Kingdom where someone was concerned that her ex-partner withdrew his consent to the storage and use of jointly created embryos. And in that instance, the court found that under English law, an embryo did not have independent rights or interests and could not claim or have claimed on its behalf a right to life under Article 2 of the ECHR. We then read in Article 6, or number 6 of this advice to us, it follows from the principles above that the draft law does not give rise to issues of compatibility with Article 2 of the ECHR. What I want to have from the Attorney General, sir, is legal advice, which we read, this is not legal advice, it is information for states members. So is the legal advice to states members that the fetus does not have any rights? I'm asking this for certainty, sir. Yes. So that is my question to the Attorney General. Does the fetus have any rights? Thank you.
Thank you. Yes, Attorney General.
Well, the question arises within the context of the European Convention on Human Rights. The ultimate arbiter of what that convention means is the European Court of Human Rights. The guidance that is set out in the report, I'm happy to adopt and repeat as legal advice to the Assembly. because it accurately sets out the position that the arbiter of the Convention on Human Rights has thus far taken, and that therefore reflects the position for the purposes of this debate. The Article 2 right, and perhaps I should just clarify, I think when I previously commented on competing rights, it was in the context of assisted dying, where a person is, as it were, living outside the womb. But the approach that the European Court of Human Rights has taken, and it's set out in the guidance, is this: that in the absence of any European consensus on the scientific and legal definition of the beginning of life, it is within the margin of appreciation that states enjoy to determine the extent of protection accorded to the right to life of an unborn child under national law. So that is the position as far as the European Convention is concerned. It is a legal issue. It is, of course, different from an ethical and moral issue about the right to life.
Thank you.
Thank the AG, sir.
Thank you. Does anyone else speak on the principles of the draft law? Deputy Ward.
And I just rise to say just a very small piece in all of this, and it's around shared responsibility for pregnancy. Because both partners participated in conception, I do believe that men do have a moral stake in decisions about continuing or ending a pregnancy. The concept of shared moral responsibility in relationships needs to be recognised. So I was pleased to hear the Social Security Minister reference this in her speech, recognising that important family decisions should ideally be joint ones. In my opinion, there is a moral argument that excluding men entirely risks undermining the emotional significance of the decision for them, especially if they desire parenthood. The idea that men can experience grief or loss when a pregnancy ends is real. I would therefore like to see reference to counselling for partners, something not currently referenced in the law. Thank you.
So would the member take a point of clarification?
Will you set a point of clarification?
Not really, sir. I'm fine.
Thank you. Does anyone else wish to speak on the principles? Deputy Tom Binet.
Yes, sir. I certainly was going to make a point of not speaking at all here, but I was a little bit concerned by some of the things that were mentioned by Deputy Tadje, and I just wanted to stand up to assure members that my Assistant Minister has been put under no pressure from me whatsoever on any of this. Basically, I view this as territory for women to deal with, and as I say, I've kept a distance, though I have kept myself informed, and I was very grateful to Deputy Miller for clarifying some extremely important points about the complexities that are involved in finding clinicians that are A, suitably qualified, and B, actually prepared to carry out terminations after 12 weeks, because having spoken to the lead clinician in the island and knowing a little bit more about exactly what's involved, it's not an easy business at all, and I think Deputy Tadje would perhaps do well to inform himself of some of those difficulties. I also took some exception to what Deputy Balash said, and I think that was very well covered by, yeah, so it's been covered, and I'm very happy with that. Thank you, sir.
Thank you,
and if I can, before I finish, I'd just like to thank my Assistant Minister for all the good work that she's done.
Thank you, Deputy. Deputy Wilson.
Thank you, sir. I won't take much longer, given some of the points have already been made by previous speakers, but clearly also want to acknowledge my thanks to the Assistant Minister for bringing the legislation forward in its current form. So this is a very sensitive piece of legislation, and I don't believe there's any legislator anywhere in the world that doesn't face controversy of some kind when debating this. But I come to this as someone who has been responsible for delivering and providing women's health services that did include termination of pregnancy services, which were freely available and responsive to need. And so I want to bring some of that experience to how legislation in this area impacts upon those who are affected by it. And one of the parts of the legislation that I've looked at is in relation to consent, the matter of consent in under 16-year-olds, and were best interest and parental consent feature. And I just would like some further clarification, if I may ask, for how the current proposals will address the very difficult issue of trying to respond to somebody as young as 11 when in this situation. And I've been in that situation where there's been an 11-year-old unable to really comprehend the enormity of what is involved and what's actually happening to them, and more so what it would mean for the rest of their life. And that's very different to actually engaging in a discussion about consent with a 16-year-old who has been fully informed and knowledgeable of the decisions that they wish to make. That said, I fully support the autonomy of young people, but I would like to ask whether the Minister thinks that the law has gone far enough in protecting and upholding the rights of the child at such a young age in this, and whether there are any other further safeguarding issues that we do need to consider here. Particularly for those children who don't have parents who can provide any parental consent, or you know, who are under the care of others. I broadly support removing the outdated requirements, and I accept it's not an issue to resolve around the precise limits and the criteria that have been used for the dates at which a termination can take place. But I would argue that it's not only, as Deputy Tadier has pointed out, a women's right issue to choose, but how and in what way she makes that choice. And there are so many other issues that inform this decision. And when it comes to later pregnancies in particular, there are serious clinical issues to consider that affect both the well-being of the woman and the fetus, and the choice that follows thereafter. And that brings me to the issue around the workforce, because I am concerned that we are, or it seems to be that we're designing a law around the availability of the clinicians we have now. And I do want to seek some clarification from the Assistant Minister as to whether or not the law is written in a way that would allow anybody to come to practice termination of pregnancy, particularly for women in the later stages of pregnancy. Because I think we should be thinking about that in the future as to what kind of service we want to provide to women in this position that prevents them from having to go off island. And I also accept all of the clinical arguments around the safety and the practice, but I do think that that is not particularly a reason why we shouldn't create the conditions in the law to enable later termination of pregnancy to happen on the island. I also want to tackle the issue of, people have mentioned reducing the stigma of the termination of pregnancy, and I think this is a very interesting choice of language that we continue to use. The concept of stigma was developed by a sociologist called Irving Goffman in the 1960s, and he defined stigma as a socially constructed mark of disgrace that reduces a person from a whole and unusual person to a tainted and discounted one. And I just want to leave members with that thought, because I think the principle of the idea that, you know, we are talking about termination of pregnancy as a law to actually address the stigma associated of it. I think I would like to see whether there was room in the law, in the principles, to talk about this in terms of a traumatic healthcare event. It is a healthcare need, it is a healthcare issue. And I think when we start to change the language around this, then I think we start to address some of the concerns and some of the lack of understanding that people have about the reasons why women seek termination. I also think that the law at the moment, as it's written, does provide for dignity, confidentiality and respect, but I would ask if the Assistant Minister could address that point in terms of the traumatic elements of this rather than the stigma elements of this, so that we can start to move away from the notion that termination of pregnancy is a mark of disgrace. So I welcome the law coming forward and the scrutiny panel's work on it, but I think, like others have expressed, I can't help feel through the commentary from the scrutiny panel in particular that we've just about managed to squeeze through the threshold for changes that women were seeking. So for me, the key is to the effective implementation and operation of the law and how it will be achieved. It will be important to make sure that the clinical pathways and access to service issues are addressed, and I certainly look forward to seeing this going forward. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? No one else wishes to speak. I call upon the Assistant Minister to reply. Assistant Minister.
Thank you, sir. I would like to thank the Assembly for its respectful consideration of this complex and sensitive subject. I would like to thank all those who have worked so hard to bring this draft termination of pregnancy law to the States for debate. And I thank all those islanders who took part in not one, but 2 consultations. I do not intend to respond to everything that has been said, but I'd like to address the following. In response to Constable Lewis, whilst hearing his concerns about the 22-week gestation limit, there are many other jurisdictions, including the UK, that permit terminations up to 24 weeks. The 22-week limit has been very, very carefully considered by many of us for very many hours, in fact years, I think, and decided upon. I believe there are examples of babies born just after 22 weeks who have survived, but the proposed law is providing for termination on any grounds before 22 weeks. In 2023, 92% of terminations in Jersey were early terminations. They took place under 10 weeks gestation, and that is what we would really encourage any woman in this position to do, to go early. So data suggests that the number of these later stage terminations will be extremely small. In answer to Deputy Dublay's question about the counselling service, I can confirm that anyone requesting a termination is informed about counselling before they proceed, and they can access the service whenever they need to, before and after. And I take on board the fact that there is a partner, and if they are affected, that we will provide sort of support for them as well, because I do understand that it is their grief, but I think ultimately it's a woman's decision. Termination continues to be a paid-for service in Jersey, and this is just because we're going to be doing work on the contraception in the island, and as part of the women's health strategy, and we will look at this, but at the moment I think it would be not a sensible idea to make any changes. I did make some changes when I came into my post, and I made exemptions for under 18s, for full-time students, women in income support households, and any woman who has a medically necessary termination regardless of gestation period, and also anyone whose pregnancy has resulted as the result of sexual assault, incest or rape. In regard to the safety zones around the clinic, I think it probably could be extended to IVF clinics, but I hope in our island, sir, that we will never need to have a safety zone. I don't want to become like the United States of America. I think we're very fortunate in living in an island that we all respect one another. I'm just trying to think whatever else we need to say. We'll be closely monitoring and evaluating service going forward, identifying and removing any ongoing barriers to access, and revisiting the issue of extended gestation periods for non-serious abnormalities as identified by Deputy Byrne. I think the scans, perhaps at 20 weeks, perhaps it's something that we need to look at. Perhaps they should be slightly earlier. Perhaps they need, I'm not sure whether that's something that could be done, and then there would be more time. I thank Deputy Dublé for her comments about remote access to the termination of clinic for women who may be in coercive or abusive relationships, but our preference is to see the woman in person for her safety. Women will be able to contact the clinics directly, herself, by email or phone, and we want all women to know that there is support available to them through Frida and Dewberry House. In relation to Deputy Miles' comments, I would say that we all greatly value anyone with a disability on this island. We all agree that Ellie was an inspiration on Strictly Come Dancing, and that we all saw her ability. Jersey is enriched by all who live here. Everyone is unique, precious, and valued. So I have a wonderful sister-in-law who has severe learning difficulties. Our family love her to bits, and we all benefit because of who she is. In adopting this law, we will be bringing forward new provisions that better reflect current societal values, take account of changes in clinical practice, and meet the needs of women who are faced with making a difficult decision. For many, if not all, probably the most difficult decision they will have to make. I do not want women to continue to have to cite distress or to feel stigmatised, although I understand that's not what Deputy Wilson is saying, who says we shouldn't be saying that. I realise it's a medical something that happens, and it's very unfortunate. I do not want anyone to fear criminalisation. And I'd like to go back to Deputy Wilson's comments. At the moment, if a child, a young person, has capacity, then they can make their own choice. And if they're younger, then it will be the person who is in charge of their well-being, who will be making the decision, the informed decision with them. I think it's a very, very difficult decision for a young person. So I know from today's debate that some of us hold different views about termination. Indeed, I may be one of them. But it is nevertheless our responsibility to provide a safe, effective, legal framework for terminations, and to provide safe, efficient, kind and compassionate care. We know that islands support change. Updating Jersey's legislation in this important area for women is necessary and carefully considered. Sir, I commend this draft law to you, and I call for the appel. Thank you, sir.
Thank you, Assistant Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting.
Sir, if I may, it's Deputy Morrill.
Did you vote in the
The chat was taking a very long time to come up. I was trying to engage before the closing of the voting. If it's not too late, then my vote is poor.
The principle's been adopted. 41. Three votes poor, 2 votes contra, and 1 abstention. Yes.
The Conotop of St Peter abstained, and those voting contra, the Deputy Gorst and Deputy Balash.
Deputy Dublé, do you wish to confirm your panel do not wish to scrutinise the matter further? On her part.
I believe she's had to go.
We do not wish to call this in, sir.
Thank you very much, Deputy. Assistant Minister, how do you propose the articles in second reading?
Please may I take them on block, sir? Thank you.
You may.
Sir.
There'll be a separate vote on Article 17, as you've indicated you wish. Are the articles seconded in second reading?
Yes, sir.
Thank you. Does anyone wish to speak in second reading on the articles? Deputy Rob Ward.
So just say on Article 17, after asking the Attorney General, a minister can set fees at 0. And I want to put on record that I do believe that healthcare should be free at a point of access for everybody. That's the way in which we have a healthier society and a better society. Thank you, sir.
Deputy Gardner, then Deputy Moore. Deputy Gardner.
Thank you, sir. And just follow up, Deputy Moore, and also thank you for Deputy Moore for raising this Article 17. And if the Minister would consider to take vote on Article 17 separately, I would welcome, because I truly believe this needs to be free at the point of access.
Thank you, Deputy Moore.
Thank you, sir, because this point is important about the fee. The Assistant Minister, in her proposition, has outlined the charging that she intends to introduce, and therefore the Assembly is left really with no option other than, especially as she did not refer to it in her summing up, the Assembly is left with no option other than to accept initially the charging system that the Assistant Minister has outlined in her proposition. And so how, unless the Deputy is going to commit to an alternative avenue right now, how can the Assembly actually vote for Article 17 if they feel that this should be a free service when balanced against other services that are offered for free? I do feel that the Assembly is in a tricky situation here, and it is a very serious point of principle for many of us. So I hope that the Assistant Minister will be able to set out her view and whether she proposes to make any changes to the proposed charging scheme before we vote on Article 17. Thank you, sir.
Thank you, Deputy Dublé.
Thank you, sir, and apologies, I didn't manage to inform the Assembly that I needed to be away for a medical appointment, but I'm grateful to be able to join online. And I just wanted to pick up on something that the Assistant Minister gave some clarification, but I wanted the certainty around the availability of the counselling and whether that would be available genuinely in short order to people who requested it, so within a few days or a week. For those who need that. And I also feel that the charging, I'd like to take that separately as well. If the Minister could respond to another point about the charging, would she include single parents in this? If there were still to be charges, would she exempt single parents and anyone experiencing abuse?
Thank you, Deputy. Deputy Sherman.
Yes, thank you. And I also support taking this separately, but I was wondering if, of course, we're talking, and the Attorney General read out the Article 17, where it's not just about the fees for the services of termination or related services, but about the counselling. And I was just wondering specifically if the Assistant Minister could talk about the proposed, what she has in mind in regards to charging for counselling services, because we've heard, of course. in the Article 17, it says specifically provide for fees to be charged for termination services, termination-related services, or counselling services provided in connection with termination services. So though I'm hearing the Assistant Minister is saying that at the moment they're free, of course, in voting for Article 17, it could give the Minister, by order, the ability to charge for counselling services as well, as my understanding. So I was just wanting to get some clarification for that.
Thank you, Deputy. Does anyone else wish to speak in second reading?
So is it possible to ask a question at this stage? I know I spoke, I missed something out.
Question of the Attorney General?
No, of the Minister.
No.
I thought it wasn't, but I thought I'd give it a try. Thank you.
No, you can't. Deputy Renouf.
So just a point before Deputy Ward finishes his speech.
He's made his speech already. That was a question he's not going to ask.
Was that a speech though, or a question?
He's made his speech already. Deputy Renouf.
I wonder if I'm not sure I want to speak, but I would like to just clarify something with the Attorney General.
Yes, we'll do that.
In relation to his previous point of clarification on this.
Yes.
It is clear that the fees order, this fee-making power in Article 17 says, but can he clarify if the practical effect of deleting Article 17 would be to effectively make all termination services in the island free, or would it only apply to late termination services? Can you just clarify what the actual effect of it would be in the broader picture, if you see what I mean?
Attorney General.
Well, I think I can only advise on the law, not necessarily practical effects, which I think are not matters for me. There is no other, well, this is a statutory process. So it provides certain powers as part of that process. Those powers don't exist out with the process because it's a statutory process. Article 17 gives a permissive power to the Minister by order to charge fees for termination services, counselling services, and in connection with termination services. If that is removed, the Minister does not have a power in law to charge, because this is the law that sets out how the system works. And so that will be the practical effect. If there's a termination service, unless there's a statutory power to charge for it, the Minister won't be able to charge for it.
And just for final clarification, there are no other statutory instruments available that might not be sitting in this law that would give the ability for the Minister to charge for this service. I really want to nail the effect, the real effect of this.
Attorney General.
Well, that might take some research because I don't have immediately at my fingertips every piece of medical legislation involved. I think the better answer will be the one I've already given, which is that this sets up a statutory procedure, and it is this law that one looks to see what fees can be charged or not, and not out with the ambit of this law. So, I mean, I can't for certain guarantee that that answer is the right one, but applying first principles, it really ought to be, because this law sets it out.
So I would also want to speak, but I don't know where I sit in the queue.
You're next.
Can I ask a further question of the...
Yes, of course. Deputy Alves will do your question first.
So currently, I'm just seeking some clarification. Currently, there is a charge, which is outlined on the Gov website as £185. If this is voted against and falls away, does that charge automatically also fall away? So basically what I'm asking is what is currently in place to allow this charge to be happening currently at this very moment? Thank you.
Well, I'd have to look at the existing termination pregnancy law. That might take a while.
Deputy Renouf.
Yes, sir. I think these questions hint at a sort of a great uncertainty that sits here around the situation where we vote on Article 17. I don't have anything to say about the other articles, but I do have significant concerns that we might vote against Article 17 without knowing the full implications of doing so. I have enormous sympathy with as I said in my short speech earlier, I do think there are significant issues of equity raised by the charging of fees for terminations. And they should, and I think there is a place to address them. There should be a place to address them. But, you know, it feels to me that that's a significant budgetary issue. I think it would be interesting if the Minister could address the question of how much what the financial effects of charging would be, of not charging rather, would be, because clearly it is a paid-for service, and therefore if it becomes a non-paid-for service, we will effectively be making quite a significant budgetary decision sort of on the hoof, so to speak, and that doesn't feel particularly, I don't feel particularly comfortable with that. So I'm waiting further clarification from the Attorney General if he's able to provide it. But I do feel like I would be very reluctant to vote against an article in this law without understanding the full implications, notwithstanding the fact that I do have a lot of sympathy with the principle that termination, you know, that there are barriers to equal access implicit in the charging for termination. However, that is the current situation, and this debate was not set up as a debate about whether or not we would be removing charges for termination, and I feel uncomfortable that it might extend into that territory without us understanding the full implication.
So may I ask a point of clarification of the Speaker?
Prepared to give way?
Yes.
Is the Speaker aware that there are 280 abortions in 2024, each of a cost of £185 if everyone was charged? So therefore it's £51,800 is the cost for those abortions. Although some
really
would not have paid.
That's not really a point of clarification, but...
No, sir, and I have seen different figures in terms of the travelling to the UK costs as well that are implied as well. So I say I think we don't really have clear clarification at the moment, and in the absence of clarification from the ministerial team is what I would take as being the definitive on that.
A question from Deputy Morell to the Attorney General.
Thank you, sir. If I could ask the Attorney General, in Article 17, the ability for the Minister to apply fees, that is a wide-ranging ability, is my understanding. And the Minister himself could choose to apply, for instance, a zero-rated fee for residents of the island, but apply fees for non-residents. For example, does the Article 17 give the Minister those sorts of powers, those wide-ranging flexible powers to apply a range of fees and not necessarily just one fee?
Attorney General.
Yes, it's broadly drafted, so that is possible.
Deputy Tadier.
Yeah, what we're seeing here is lots of members standing up trying to find innovative ways to interpret Article 17 to ask the Minister not to charge fees. The simple thing to do is just not to vote for Article 17, then the Minister doesn't have the ability to charge fees. The Attorney General has already told us that a zero fee can't be charged across the board because that wouldn't be a charge. So we can't get away from this fact that this is a political choice here that we're making today. And effectively the recommendation from the scrutiny panel has been that these charges, you know, healthcare, reproductive healthcare, should be free. It's also a party position, by the way, I remind my party colleagues who are also ministers, and that the simple thing to do here is simply to vote against Article 17, then the Minister won't have an ability, because this Assembly, we get this strange scenario where Deputy Morell is asking a question saying, you know, could we charge zero rate for local residents? I mean, I didn't necessarily know that these terminations are going to be marketed, so to speak, to non-residents. Although, of course, you might then have that very strange situation where somebody who's not been here long enough also needs to access those services and would be charged versus, and there'd be an equally emergency need or whatever other need, and then we're starting to discriminate against women based on how long they've been in Jersey. So I think the simple thing here is simply to vote against Article 17. And that sounds like what a lot of ministers want to happen anyway. I would ask the Minister to clarify, because Deputy Ward ingeniously got up and stated some figures. So he believes that there are currently 280 terminations that took place in 2024, all at a cost of £185, which, if you do the maths on that, adds up to £51,000. Now, if those figures are not accurate, it's up to the Minister to tell us. But it seems to me that if we can't find around about £50,000 or that ballpark figure in an annual budget of over £1 billion, and we're taking women's rights seriously in this Assembly, as I've said during this week, we've been focusing on VOG, but what about actually more general women's rights? I think £51,000 is less than £1,000 a week, isn't it? And I don't know what that divides up by 100,000 people living in Jersey. I think that actually this is a strong message that we can send to the Minister. This should be a free service. The other point I think is counselling is really important. I'm really glad to see that the counselling services are required. And I did ask a woman who's close to me, I said, is that the right thing to be in the law? The way it's worded, is it right that it's worded in that counselling service must be offered to a woman? I said, could that be seen as the necessity of that, the obligation of that? Should it not just be that counselling services are offered rather than, required to be made, or i.e. there's a leaflet over there if you want some more information. And she said, no, actually, it's absolutely right that government should be and doctors should be providing the opportunity for counselling if women want it. And what that does also mean, of course, is that on the one hand, it might mean that they can do the counselling afterwards, but it means that they're able to do it in advance. And it also might mean that they talk through the issues, which are not just physical health issues, but there might be social and financial issues that they think about. And it might mean that they change their mind one way or the other. And I think that's also valid. And I think that actually there's a greater cost here rather than just the financial one. And so I think if all of these services in the round can be taken as being available to women and without any financial barrier, I think that is something that should be worthwhile, sir.
Sir, could I ask a question of the Attorney General?
You may.
Does the 1997 law include any reference to fees at all? Because my reading of it online is that there's nothing there currently, in which case I'd like to know how the legal position for charging fees currently, where that stands. Thank you.
Mr. Attorney.
I'm about to apologise to the Assembly. I don't think the advice I gave earlier was necessarily correct. It is right, there's no order-making power to charge fees in the existing law, and there is no ministerial order that I can find to charge fees. I understand that fees are charged across our health service as a matter of policy. So I don't think the advice I gave was correct. What Article 17 does is provide the Minister with a power, if he or she wishes it, to set fees for this particular service. But I understand that generally across the health service, as I say, fees are charged as a matter of policy, and it's on the basis of user pays. And I apologise for not being clearer about that earlier.
So could I just follow on from the advice of the Attorney General, say what that means?
Are you speaking now?
No, I'm asking a question.
I see.
What that means, sir, is that even if this article should be voted down, the Minister would have the ability under general policies to charge for the service.
Yes, I think that's right.
Can I just add a further clarification?
Yes, of course.
But would it mean that it would send a clear message from this Assembly to the Minister about views?
That's a political question, I think. But yeah, yes, it would. Assistant Minister, you've got your light on a lot, but you're going to reply at the end, unless you're going to do something unusual in the
Sorry,
way.
sir, I thought I thought it was about that time now.
No, well, it may be soon, I don't know. Does anyone else want to speak in second reading? I call upon the Assistant Minister to reply. Assistant Minister.
Thank you, sir. I would just like to repeat what I said earlier. Termination continues to be a paid-for service in Jersey under health policy. But I have made a commitment to review all the contraception services that we offer on the island for women and the termination of pregnancy. But I do not think we should be making any of these decisions on the hoof. I do not know what the figures are. I do not know what the implications are. I want the best for women on this and girls on this island, but I say we should not be voting separately on Article 7, and I'm going to ask to the appel to be called and to call for everything on block.
Members are entitled to call for a vote on a separate article, so they will
So
be.
could I ask for Article 17 to be taken separately, please?
We've already agreed that that will happen. That's the request of members, so there'll be a separate vote on Article 17. The appel has been called for. Members are invited to return to their seats. The first vote will be on Articles 1 to 16 inclusive. And I ask the greffier to open the voting on Articles 1 to 16. If all members in the chamber and remotely have the opportunity of casting their votes, I ask the greffier to close the voting. I announce that Articles 1 to 16 have been adopted. 44 votes pour, 2 votes contre. Now I'll move on to a separate vote on Article 17, entitled Fees Orders. I invite the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. Greffier. Article 17 has been adopted. 22 votes pour, 21 votes contre, and 1 abstention.
The names, please, sir.
Yes.
Do you want both votes? Those voting for, the Conotubs of St Helier, St Brallard, Trinity, St John, Grouville, St Juan, St Mary, and St Saviour, and deputies Lehegara, Ayer, Farnham, Balash, Scott, Rose Binet, Miller, Howell, Tom Binet, Ferry, Alex Curtis, Barbara Ward, and Deputy Andrews, and online Deputy Morale. Those voting contre, the Conotubs of St Lawrence, St Peter, St Martin, and online the Constable of St Clement, and deputies Southern, Tadier, Rob Ward, Alves, Gardner, Moore, Mezek, Coles, Porre, War, Miles, Catherine Curtis, Baltham, Jearn, Wilson, Stevenson, and online Deputy Dublay, and Deputy Reniff abstained.
I'll move on to the balance of the articles. Articles 18 to 24 inclusive. I ask the greffier to open the voting. For all members, the opportunity of casting their votes. I ask the greffier to close the voting. I can announce that the balance of the articles have been adopted. 44 votes pour, 2 votes contre. Assistant Minister, do you propose the matter in third reading?
Yes, sir.
Is the matter seconded in third reading? Thank you. Does anyone wish to speak on the articles as adopted in second reading in third reading? No one wishes to speak.
So I put my request on there.
Thank you then,
Chat
Deputy
online.
Dublé.
Thank you. I just wanted to reiterate my request to the Assistant Minister. Now that Article 17 has adopted and there will be charges, would she exempt single parents and anyone experiencing any type of abuse from those charges?
Thank you, Deputy. Does anyone else wish to speak in third reading? Thank you. I call upon the Assistant Minister to reply. Assistant Minister.
Thank you, sir. And I'd like to reply to Deputy Dublé that we will be looking at all the charges for contraception and for termination, and I say that I will do that. But before I call for the appel in third reading, I would like to take a moment to thank the scrutiny panel for its comments on the draft law. I would also like to extend my particular thanks to the members of the Women's Health Political Advisory Group who have provided their wisdom and advice and supported me in the development of this draft law, and for all the officers who have worked so hard on this for a very long time. And I would like to thank you, all of you, my fellow states members, for your thoughtful and informed contributions. And sir, I now call for the appel. Thank you.
Thank you, Assistant Minister. The appel has been called for. Members are invited to return to their seats. And I ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I announce that the draft law has been adopted in the third reading, 44 votes for, 2 votes contra. The next item is the agreement between the Government of Jersey and the Government of the Kingdom of Bahrain, elimination of double taxation, taxes on income and prevention of tax evasion avoidance, lodged by the Minister for External Relations. The main respondent is the Chair of the Economic and National Affairs Scrutiny Panel. I ask the greffier to read the proposition.
The States are asked to decide whether they have an opinion to approve the text of the agreement between the Government of Jersey and the Government of the Kingdom of Bahrain for the elimination of double taxation with respect to taxes on income and the prevention of tax evasion and avoidance, as set out in Appendix 1 to the accompanying report.
Minister.
Sir, before I deal with the substance of the proposition, I would like to state our condolences and support to the Kingdom of Bahrain in the wake of ongoing attacks they have experienced from Iran and its regional proxies, which have caused multiple civilian deaths and casualties. It is an established process that the Minister seeks the approval of the Assembly prior to taking the steps to bring double taxation agreements into force. This procedure was further codified with the approval last month of the draft treaties, Jersey law, as treaties signed under an entrustment from the UK. DTAs are covered under Article 2 of the draft law. DTAs are agreements between two jurisdictions that are primarily designed to protect taxpayers against the risk of double taxation of income and provide certainty to tax treatment for their cross-border activities. Widening Jersey's network of bilateral tax agreements for the benefit of islanders and island businesses is a key part of the common policy of external relations that has been pursued by successive Jersey governments. Engagement with Jersey's financial and related professional services industry has demonstrated support for Jersey delivering a wider network of DTAs, especially with jurisdictions such as Bahrain, where business flows are well established and where there is regular exchange of professionals. The Jersey-Bahrain DTA is the 16th full DTA Jersey has signed. It builds upon our treaty network in the Gulf, which, as has been identified in the ongoing work of the Financial Services Competitiveness Programme, remains a vitally important region for Jersey from a commercial perspective. Bahrain already has DTAs in place with 45 other jurisdictions, including the UK. So it should also be noted that the completion of a DTA was outlined as an objective in the government-to-government Memorandum of Understanding signed between Jersey and Bahrain in 2023. Negotiations over the DTA took place in a cooperative manner and were helped by both Jersey and Bahrain using the OECD Model Tax Convention as a basis. The agreement, which members will have seen an annex to this report, represents a modern and balanced treaty which incorporates updated international standards on tax transparency and anti-avoidance measures, and the ongoing developments regarding the implementation of the OECD's Pillar 2 framework were also reflected in the negotiation of the text and its accompanying side letter. Under the terms of the DTA, Jersey individuals and companies in Bahrain will not suffer from punitive double taxation, whereby income can be taxed in full in both the country where the activities take place and in their country of tax residence. These provisions will remove barriers for individuals and businesses operating between the two jurisdictions and encourage greater levels of investment into, from and through Jersey. This in turn is anticipated to bring benefits for the island's financial and wider services sector, with potential to create more businesses and support more jobs in Jersey over the longer term. The conclusion of the DTA comes at an important moment in light of the planned UK GCC free trade agreement in which Jersey hopes to participate. The expected growth of trade and investment under the FTA can multiply the benefits of the DTA. Taken together, the agreements will reinforce Jersey's value as a conduit for capital flows in the triangle between the UK and GCC. It is vitally important that Jersey continues to make its business environment as attractive as possible for international businesses, and by expanding the island's own treaty network, this will help to safeguard our competitive position. Upon receipt of confirmation that Bahrain has completed its equivalent procedures, the agreement will enter into force. We anticipate entry into force to occur before the end of the year, allowing the agreement's provisions to take effect from the 1st of January 2027. So I commend this agreement to the Assembly, and I am, of course, grateful to the scrutiny panel who have scrutinised myself and my department and on this matter and the treaty itself. So I propose the treaty to members, sir.
Thank you, Minister. Is the proposition seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the proposition? Antonio.
Thank you, sir. Just briefly and on behalf of the panel, so we are grateful to the Minister for having provided briefing materials to this and having engaged in and replying to correspondence, sir. So the panel did question the Minister in written correspondence on the rationale for the double taxation agreement with Bahrain specifically. The Minister stated that engagement with Jersey's financial and related professional services industry has demonstrated support for pursuing a wider network of DTAs, especially with jurisdictions such as Bahrain, where business flows are well established and where there's a regular exchange of personnel. And the Minister said that without a double taxation agreement in place, Jersey firms and individuals operating in Bahrain could be subject to punitive double taxation. And whilst the personal and corporate tax regime in Bahrain is relatively low, the DTA does provide additional long-term certainty on this point, sir. The panel did ask, as it often does, about the economic benefits. So we do see DTAs being passed routinely. When I say routinely, that doesn't in any way mean that the tax agreements themselves are in any way easy and without complexity, and indeed not unique in every case. But I think it is important for us to ask, what does this bring for our local community and what are the economic benefits of signing up to these DTAs? So the response we got from the Minister was, whilst these benefits can be challenging to monitor and measure directly, the DTA will act as an important enabling factor for increased business flows. We have engaged and we believe that there's important commercial activity, and we will continue to monitor the impact of DTAs through industry consultation via Jersey Finance. So I think it is important that, especially when some of these economic benefits are not always visible, that there is some form of KPIs in place, and that the Minister does give us regular updates when there is evidence of financial benefit to the island from these. It is perhaps unsurprising that the panel also asks, it's almost like a tick box exercise that we have with some of these jurisdictions that we do business with, about human rights considerations with regard to the Kingdom of Bahrain. So the panel did express concerns regarding the state of human rights in Bahrain and sought clarification from the Minister on how this had been considered. The Minister advised that in the government's view, progress in this area is most effectively advanced through constructive engagement at both political and commercial levels. The Minister confirmed that whilst in Bahrain, he had reaffirmed Jersey's commitment to upholding the rights and freedoms of individuals around the world, with senior UK counterparts and the Bahraini ministers. The Minister further commented that further progress is always possible and that he remains committed to engaging in constructive dialogue with partners, including Bahrain, and on strengthening human rights standards. So whilst the panel acknowledges the Minister's response to its questions on this matter, it remains concerned about the state of human rights in Bahrain and believes that this should be monitored closely. We didn't really ask whether Bahrain had any concerns about our human rights in Jersey, but that's probably beyond the remit of our panel, sir. So in conclusion, having reviewed the agreement and the information provided by Minister and his department, so the panel is satisfied that the agreement is consistent with international best practice, supported by appropriate transparency provisions and aligned with Jersey's economic interests. The panel is therefore broadly supportive of the agreement.
Thank you, Deputy. Does anyone else wish to speak on the proposition? I call upon the Minister to reply. Minister.
Thank you, sir. As I said in my opening comments, I'm grateful for the engagement of the panel in this matter, and I commend the agreement to the Assembly, and I encourage them to, in effect, ratify it. So I call for the appel. Thank you.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. Give all members the opportunity of casting their votes. I ask the greffier to close the voting. Proposition has been adopted unanimously, 42 votes for. The next item is the draft sea fisheries, trawling, netting and dredging amendment regulations lodged by the Minister of the Environment. The main respondent is the Environment, Housing and Infrastructure Scrutiny Panel. I ask the greffier to read the citation.
Draft Sea Fisheries, Trawling, Netting and Dredging, Jersey Amendment Regulations 2000. The states make these regulations under Articles 2, 5, 6, 7 and 29 of the Sea Fisheries Jersey Law 1994.
Minister.
Thank you, sir. Sir, I'm pleased to bring to the Assembly today these amended draft Sea Fisheries, Trawling, Netting and Dredging Jersey Regulations, known generally as the TND Regs. These regulations control some of the most complex and controversial fishing techniques practiced or prevented from use in our waters. They are therefore, in turn, lengthy and technical, even by the standards of fishery regulations. The updates proposed today are for the most part scientific, technical measures of relevance for modern fisheries management, which I'll explain with a brief overview in a moment. At the back of the regulation, there's a rather long set of tables that will, I suspect, draw most of the attention of my fellow members here today. Schedule 1A contains details of the current and future Marine Protected Area, or MPA, network for the island. The update to the schedule is the delivery of a widely discussed and debated process one that has been the focus of much public and political interest in recent years, months, and even days, with the letter of 2 States members this week from our local fishermen. Originally set out in the Bridging Island Plan, the designation of a network of MPAs was driven through the Marine Spatial Plan, which in turn this Assembly voted through in October 2024. As part of that debate, I accepted, and we collectively voted through, an amendment from my scrutiny panel relating to the delivery timeline for that MPA network. Today, I hope we will make good on that commitment to deliver an MPA network in this term of government. In considering those amendments, I ask members to keep in mind that any changes we might make today will have real impacts on the lives of the island's fishing community. These are measures designed to help ensure a sustainable future for that sector. Fisheries management in Jersey is never simply a technical exercise. It's about balancing livelihoods, heritage, and our duty of stewardship to the island's marine environment. The Assembly will notice that, as well as updating the TND regs, this draft regulation proposes to repeal other inshore TND regulations. The current 2 pieces of regulation were set out in parallel at the time when France managed its fleet in our waters, while we managed ours. However, since the introduction of the Trade and Cooperation Agreement, the TECA, we are now in charge of the management of all vessels in our waters, so we can now administer them under a single TND regulation. It's not often that we get to make fewer laws, but we should perhaps celebrate when it is achieved. All relevant elements of the inshore TNDs have been moved across into these new regulations. This not only makes it simpler for fishers and for the fishery officers, but also removes disparity on how we manage our waters inside and beyond our own 3-mile exclusive area. The amendment also carries updates to the minimum size limit regulations, licensing of fishing boat regulations, and the miscellaneous provisions, all of which also fall under the Sea Fisheries Jersey 1994 law. These regulations, along with the fishing vessel licence conditions, have harboured elements of fisheries management over the last several years. However, with this review, those elements best suited to it can now be rehomed in the modernised TND regulations. Framing these elements into a single regulation simplifies the challenge of compliance for fishers and creates a more stable and ultimately sustainable situation for them to plan their business activities from. The Assembly will note several updates to specific terminology and definitions that reflect changes in commonly used fishing language and UK and EU policy. While these do not materially change the function of the law, they reduce ambiguity and the potential for legal grey areas. The letters E and C are added to the net measuring tool names in the regulation in order to meet European and UK design and build standards. And the consistency of the word fishery or fisheries officer is regulated as both are currently used in current laws. I'd like to talk a little bit about nets and start by saying that the approach to the mesh size of trawl nets has been simplified. In the past, our regulations mirrored the old UK regs and rules in requiring specific combinations of net mesh sizes to be used when targeting certain species. Now, a minimum mesh size is set at 80 millimetres for trawling, irrespective of the species being targeted. This allows the majority of undersized fish to escape, especially when combined with features such as square mesh escape panels, and those panels hold an open grid of meshes in the top of the net to aid the escape of smaller fish. As minimum size limits for fish species increase, it's intended that the mesh size will also rise, to which end an order-making power is proposed to allow for the increase in net size with developing fisheries management advice. These measures are designed with economic and environmental sustainability in mind. A special circumstances is going to be created for draw nets or seine nets or nets that are encircling for the catching of sand eel. This is a species prized as a bait for bass. It will be fished in a specific no bycatch fishery using nets of 55mm mesh or less and with a length no longer than 70 metres. Until now, and through an oversight in the original drafting, this common practice has technically not been legal inside Jersey's 3-mile limit. Again, an order-making power is prescribed here to allow for changes to mesh size and permitted species as new fish stocks enter our waters. While it's vital we regulate for today, it's also important that we are adaptable for tomorrow. Various technical measures are brought together or introduced here, sir. The first is the prevention from use of electric current to drive fish or shellfish from the seabed into nets. This is a fishery with unknown side effects, and Jersey is not the place to test it. The second is a reduction in bar length of beam trawl to reduce size of the net that can be used and the associated seabed and fishery impact. The third is a decrease in the twine thickness for certain meshes in towed nets to improve the flexibility of the nets and the likelihood of juvenile fish escaping. While the size of scallop dredgers is not changed at this point, in partnership with the industry, it's been agreed that the size of the dredge rings will increase by 7mm next year in the spring to reach 92mm, with a further move likely before 2030. To this end, an order-making power has been drafted to allow for management improvement in real time. Members may question the need for order-making powers to control the size of mesh and rings on trawls and dredgers, but I can say from experience that nothing frustrates the fleet more than having an agreed conservation measure held up by the need for assembly time. I hope members will agree these delegations of power from the Assembly to the Minister are suitable in the interest of swift management for stock conservation purposes. So I'm proud to be able to say that Jersey has one of the best managed bass fisheries in Europe. The advantage of our small size that means we have been able to regulate and adapt to the scientific advice provided by ICES, that's the International Council for the Exploration of the Seas, as it develops. We now have over 20 boats involved in a small but profitable, low-impact fishery using both rod and line and purpose-built 100mm mesh gill nets. Now is a good time to increase the size of the net and standardise measurements across the board so that all commercial static nets, not just those for bass, are at least 100mm in size. Similarly, we propose to take the measure even further for recreational netting, bringing the size to 112mm. This is not to disadvantage the recreational fishermen, but to allow them to target a feed of flatfish or the chance of an odd big bass or large mullet. A further restriction on static nets, in line with the Marine Spatial Plan objective of reducing interaction between fishing nets and recreational users of the sea, is to be introduced. From the 1st of April to the 15th of October each year, static nets must be kept a minimum of 200 metres from the shore around the island's entire coast, no longer just the south and east coasts. Nets will also need to be marked with a distinct red and white float so that swimmers and kayakers can identify them easily. These floats have already been distributed to some of our fishers who are beginning to use them on the merits of the safety improvements they bring. Netting can get a bad reputation, sir, especially with those that don't know the fishery. But I will say here that a well-managed net fishery, practiced by small inshore boats is a core part of the patchwork that makes up a sustainable and diversified fishing industry. I'd like to now move on to the MPA network, if I may, sir. Jersey currently protects 6.5%, 150 square miles of its waters from destructive or mobile fishing practices, including trawling and dredging. Following an exhaustive consultation process and further research, reports and negotiations, a plan has been reached to increase the size of the MPA network. Initially, on the 1st of September this year, we will protect an additional 506 square kilometres to cover 21.7% of the island's waters. This figure will be increased further on the 1st of January 2030 with the addition of another 46 square kilometres of phased area to deliver an MPA covering 23.55% of our island's waters, planned target of protecting our shallow, productive and biodiverse habitats, including critical OSPAR recognised habitats of seagrass meadows, kelp forests and marl beds. These habitats are recognised by scientists and fishers themselves as practically incompatible with fishing via trawling and dredging. Is Jersey right to close as much of the seabed to these profitable local fishing practices? While a knee-jerk reaction may for many be in the affirmative, as the Minister with responsibility for fisheries, I have spent a long time looking at the different viewpoints and listening to the different but equally passionate arguments. Fishing is a hugely important part of our island identity, and while it is the fisher's job to think about today's catch, it is mine and that of my officers to think about tomorrow's. By gradually and systematically moving dredging and trawling out of our shallow, productive habitats, we will preserve nursery grounds and increase fish stocks both for these boats and for the divers and potters that can access the areas without the same impact. We have to recognise, though, that this comes at a cost of longer steaming and fishing times for those boats moving to new grounds and, for some, investment in larger winches to fish deeper waters. It will be the responsibility of the next government to look to support the fleet in transitioning to new ways of working at the tail end of 2026 and beyond. The funding I secured for the fishing industry in 2025 will need to be bolstered to support not just these amendments, but other changes that we see being driven by our warming climate and our ever-moving fish stocks. This is the beginning of the journey to a sustainable island fishery, and not the end of it. So, if I may, I'd like to briefly address the comments made by some fishers this week, and I would just add a few points at this juncture. Fishermen asked why whole areas are being closed rather than taking a feature-based approach as in the UK. And the simple answer is that the areas we are proposing to close are predominantly the features themselves in question. Through extensive research, we have identified and refined the areas that need protection and are designating them, where in the UK, a much larger area might be designated around an area needing management. This is a targeted approach to MPA designation. Some, including my scrutiny panel, may argue that it is even too targeted, but the aim here has always been to strike a balance. Fishers have raised the issue of timelines and coordination with neighbouring jurisdictions in the MPA designations. I restate here, sir, that the timeline followed was fair and consultation extensive. The reason this regulation is being debated now and not at the end of 2025 is the accommodation I allowed of the final consultation with the fishers following publication of economic and research data and reports. I can assure members the process has been fair and open, and the data is transparent and available for interrogation through the documents published on the Marine Spatial Plan webpage. I should also note that following the publication of the final TND proposals, no further comment has been raised either by the Government of France or its fishing representatives, despite this being open to them. The fishermen asked for clear review points and safeguards to be built in for future adjustments. In delivering these regulations at this time, we are meeting the targets set by this Assembly. My team at Marine Resources will continue to conduct the research into MPAs and work with fishermen to inform the next government in its decision-making on the matter. I will finish on this topic, sir, by saying that I believe the development of the NMSP and the delivery of the MPAs to be so transparent and visible as could have been asked for, not just from an island scale, but in the context of our geographical setting, in my proximity to Normandy, Brittany, and the wider French. The fishermen have been not just heard, but listened to, and while some voices may still cry dissent, many in the industry are keen to see these changes that they believe will help all fishers in the long run by securing breeding and nursery grounds for all of our key fish stocks. In closing, members will also note the introduction of Schedule 1B, where seasonal closures, the extension of the MPA, are combined with existing seasonal bream nesting closures from the licence conditions. These elements, while they don't increase the overall percentage of the MPA network under Jersey's strict definition of protection, do contribute to marine management and protect key fish breeding sites. I'll close there with just a couple more comments on nets. Several years ago, I closed the practice of setting nets on the beach through the inshore regulations. By bringing these into the consolidated TND regs, we prohibit the same high bycatch activity at the offshore reefs. Onshore, sir, this had gone from a hobby to a large-scale fishery, with several nets being driven down the beach in 4x4s rather than individuals walking individual nets down the beach in a barrow. Separate to beach set nets, draw netting is a traditional practice that can remain as all of the bycatch can be spilled out of the back of the net into the sea alive. These days, sir, it's rarely practiced, but is wonderful to see as a traditional recreational island fishery, although based on the amount of weaver fish often caught these days, it's perhaps left to one of the very determined of us. Very finally, sir, members will note Schedule 8 and 9 provide technical terminology updates for fisheries enforcement net measuring equipment. I'll leave it there, sir, and propose the principles of these amendments.
Thank you, Minister. Are the principles seconded? Yes, sir. Thank you. Does anyone speak on the principles of the regulations? Deputy Chair.
Thank you, sir, and I rise as Chair of the Environment, Housing Infrastructure Scrutiny Panel. As members have read in our comments paper, the panel supports the overall objective of these regulations. Our marine environment is one of Jersey's most valuable natural assets, and it must be protected and managed carefully for future generations. Not only is this updating Jersey's fisheries legislation to create a modern management framework for trawling, netting and dredging, as the Minister has outlined, these regulations are an important step in delivering the marine protected area network set out in the Jersey Marine Spatial Plan. Members will recall that the Marine Spatial Plan was adopted by this Assembly in October 2024. It set out a framework for organising human and marine activity within Jersey's waters, developing a network of marine protected areas, informing future policy development and ensuring more coordinated decision-making for our marine environment. During our review of the plan, the panel made a number of findings and recommendations relating specifically to marine protected areas. 5 of those recommendations were accepted by the Minister, including the need for a clear timetable for MPA designation, meaningful engagement with those affected, and continued collaboration with the fishing industry to ensure their knowledge and data inform planning decisions. The Assembly will also remember that the scale of the MPA coverage was the most contentious issue during that debate. The panel raised concerns at the time that reducing the originally proposed coverage from 27% to to 23.3% risk the loss of protection for sensitive marine habitats. As a result, the panel lodged an amendment seeking to restore the full 27% for immediate protection. That amendment was not supported by the Assembly. Nevertheless, the Marine Spatial Plan was ultimately adopted unanimously, and it included a commitment that actions arising from the plan would be supported by clear timetable and defined responsibilities. Since that debate, further work has taken place. Additional seabed surveys were conducted in 2025 in the areas that had been deferred for further research, and the government also commissioned an economic impact assessment to examine the potential impacts of MPA designation on the fishing industry. The panel has been scrutinising the work of the Minister in relation to this work since the MSP vote and have received private briefings on both of the new reports earlier this year. While we welcome the fact that further evidence is being gathered, the panel does have some concerns about aspects of the analysis that informed the proposals before us today. In particular, the economic impact assessment relied primarily on a single year of fishing activity in an area where it was known that the data was being gathered specifically for this assessment. Ordinarily, assessments of this nature would draw on several years of activity data to ensure that the findings reflect longer-term trends, rather than short-term behaviour that may not have been picked up behavioural changes. The panel also noted the assessment focused almost entirely on the short-term economic impact of the mobile gear fishing fleet. While those impacts are important and must be recognised, the assessment did not attempt to quantify the longer-term environmental and ecosystem benefits that could arise from stronger marine protection. This is important to raise as during our extensive review of the Marine Spatial Plan, the dominant debate centred on the balance to be struck between the protection of marine habitats, biodiversity and future fish stocks, and the current economic viability of the elements of Jersey's fishing industry. The submissions and some of the subsequent meetings and hearings held by the panel highlighted the complexity of the issue and the many conflicting voices on the development of these protected areas within the fishing industry. As I said during the October 2024 debate, there is no doubt for the panel that the expansion of MPAs will have a negative economic impact on parts of the fishing fleet. The impact on livelihoods in the future of parts of the fleet is fully recognised by the panel, and it's also recognised in the MSP when it stated the proposed MPAs will require a change to fishing patterns for some vessels. However, it should be noted that in comparison to static gear, mobile gear is a minority fishing activity within the proposed MPAs, and that the fleet will remain permitted to work in 76.7% of Jersey's waters for all or part of the year. What was concerning of the economic impact assessment is that there was no valuation of potential gains from habitat recovery, improved biodiversity, enhanced ecosystem functioning, or the longer-term recovery of fish stocks, even though there is established methodology to make these calculations to understand a more balanced impact assessment with costs versus benefits. As a result, the panel is concerned the economic picture presents somewhat one-sided, capturing short-term cost to industry without recognising the potential long-term environmental and, of course, economic benefits that a healthy marine ecosystem can provide. In relation to the further research carried out on areas identified and agreed following the MSP debate, the surveys concluded that some locations did not meet the ecological criteria required for protection. As a result, certain areas, including Necro East and Minkies Northeast, have been excluded from its designation. In those cases, the available evidence indicated that habitats presented were limited or degraded, and the potential environmental benefit of protection would not outweigh the economic impact on the dredging fleet. This is good news to have that evidence available. However, the panel does note that part of the Southeast MPA area will not receive protection until 2030, but despite the research identifying medium to high densities of merle in that location. While we recognise that current fishing activity presents practical challenges, it's disappointing that protection for such habitats will not begin until the end of the decade. Looking ahead, the panel expects the next minister to bring forward the phased areas for final designation based firmly on this current available scientific evidence and to apply the precautionary principle when determining the appropriate level of protection. Sir, the panel is also disappointed that the areas of protection already approved by this Assembly in 2024 is not already designated and was not designated as quickly as we thought. When the Marine Spatial Plan was debated, their expectation was that the confirmed areas would be implemented promptly, with only the additional research areas subject to delay. That expectation was not met. Nonetheless, these draft regulations now provide the mechanism to move forward with the first phase of the Marine Protected Area designation. Under the proposals before us, MPA coverage will increase from approximately 6.5% today to around 21.7% from September, rising further to approximately 23.5% from 2030. The panel reiterates its strong support for Jersey's commitment to achieving 30% of marine protected areas by 2030, consistent with the international agreement that Jersey has signed up to. This target is an important benchmark for Jersey's long-term environmental stewardship and international credibility. While the panel agrees with the Minister that quality must come before quantity when defining protected areas, we remain concerned that some habitats identified as environmentally valuable have nonetheless been scheduled for phased or seasonal protection rather than immediate designation. In the panel's view, a quality-first approach should mean that once high-value habitats are clearly evidenced, they should be protected without unnecessary delay. Notwithstanding these concerns, the panel recognises the draft regulations represent an important step forward. They will allow the first phase of marine protected areas to be designated within a political term, something the panel was consistently calling for since the Marine Spatial Plan was adopted. The panel also welcomes the continued engagement between government and the fishing community throughout this process. The development of MPAs must continue to be based on strong collaboration with those who work on the sea every day. And looking ahead, as we highlighted in our earlier review, marine resources must continue working closely with the industry to develop fisheries management plans, further financial support and backing the exploration of more sustainable fishing methods. Protecting our marine environment and supporting a viable fishing industry are not competing objectives. They are mutually dependent. Healthy seas support healthy fisheries, and both are essential for Jersey's long-term environmental and economic resilience. So for these reasons, while noting the concerns we've raised today, the panel supports the introduction of the regulations, but we also emphasise that work does not stop here. The next phase must be guided by strong scientific evidence, continued collaboration with stakeholders, and a clear commitment to achieve the full ambition of the Marine Spatial Plan. Thank you.
Thank you, Deputy. Does anyone else wish to speak on the principles of the regulations? Conrad Robertson-Brillard.
Thank you, sir. I'm grateful to the fishing industry actually being represented here today in the gallery. They have a very close interest in what goes on, and I like to think that the government have been working closely with them to develop the process that we're talking about today. I think, sir, that we have to take care, though. The fishing industry is fragile. We've seen a massive reduction in the number of fishing vessels over the years for various reasons. One is that the cost of running a fishing vessel these days is massive, and the need to have the resource to invest in a vessel, whether it be new or second-hand, is significant. And for that investment to take place, fishermen need to have the confidence that they can go out and catch fish. And we need to take care, in my view, that we don't mess about too much with the fishing areas which they are using regularly and have been productive in the past to be able to make give them confidence in the investment which they've got. They did make some points, and I know they did circulate members with their comments, and I would urge members to read those that came round because they're very pertinent. And the Minister's referred to a couple of points, but I think that a couple of the points towards the end where they suggest that we should ensure economic safety and displacement impacts are fully assessed before irreversible restrictions are embedded in statute. And that really is terribly important, sir. We must also recognise that 30 by 30 is a policy goal, not a management prescription, and doesn't require blanket bans on mobile fishing gear. The areas being fished change, sir. They are not fixed all the time, and we need to listen to fishermen with regard to their comments on that. Also, we need to prioritise coordinated management and alignment with neighbouring jurisdictions, and we've seen various evolutions of that, and we need to use Jersey, using access to Jersey waters as part of a constructive dialogue on market access parity is so important. We've seen blockages, for instance, in Granville with the situation there, they create there, which is not accessible to Jersey fishermen, which is quite ridiculous. And I know the External Development Minister has been working with his colleagues on that, but by virtue of the fact that we have to deal with London, who then deal with Brussels, who then deal with Paris before it arrives on the Normandy coast, is far from satisfactory. And I think the final point, which I think is extremely pertinent, is that we must build in guaranteed review points so that decisions can be revisited if impacts are greater than anticipated or new evidence emerges. The sea changes all the time, sir. The economic situation of owning and running a fishing vessel changes all the time, and we must be flexible to accommodate the needs of the day. Thank you, sir.
Thank you, Deputy Renniff.
Thank you, sir. I find myself at a slight disadvantage because thanks to an epic IT fail, the speech that I'd written on this seems to have disappeared. And so I'm going to have to slightly ad-lib my comments. And perhaps members will discover why I generally tend to write my speeches before I deliver them. I do want to start by thanking the Minister and welcoming the bringing forward of these proposals, and likewise thanking the scrutiny panel for their work on this area. Members will know that the Marine Spatial Plan was something that I began into my term of office, and it is something which I hold very dear. I think this is unquestionably a complex area, but I do also think that it is an area where Jersey can excel. One of the things we often talk about is the ability to control what happens within our territory, and we usually think of that in terms of the land area, but of course we have very large territorial waters, and we have a marine resources team which I think, as I've said before and others have said before, is a very, very highly thought of at a national and even international level. And their ability to sift through the issues that we have to deal with and to come up with, in this set of regulations, a comprehensive set of changes that I think navigate their way through a very complex regulatory framework, I think is really something of which we should be exceptionally proud. And it certainly chimes with my beliefs in sustainability and in the careful regulation of our marine environment for our collective benefit. Having said that, and I will therefore not make much comment about many of the technical details of these regulations and the amendments that the Minister is bringing, but I will focus, perhaps unsurprisingly, on the question of the marine protected areas and the changes therein. It is sometimes presented as a dichotomy between environmentalism and fishing, or fishing interests in the environment. I actually would say it's more about science than the environment. I mean, this is really about science. But actually, I don't think there is much of a dichotomy in the bigger picture. Protection of high ecological value habitats is not at variance with the interests of the fishing fleet taken as a whole and over the long term. There is, however, an issue of the short term versus the long term, which we're not really addressing that dichotomy with these regulations, but I will come to make some comments on that shortly. the Constable of St. Brelard noted that the fishing industry is fragile, and there is no question that is the case. I made a speech in a previous debate about this in which I pointed out that to a very significant extent, the reason why our fishing industry is fragile is because we have consistently overfished our waters. And that was proven in the statistics I gave on that occasion, which showed that the decline of every commercial fishery was preceded by a massive peak in the catch. In other words, we fished and fished and fished, and then finally the stocks collapsed. Scallop is currently doing well, but all the indications would suggest that if we were to continue to fish at the current levels, it too will eventually reach its breaking point. So in terms of the Minister's proposals, I want to focus in on the bit which I find most problematic, because the long and the short of the Minister's proposals is that he has received results from the areas that he designated as further research. He deployed that as a reason not to designate the original MPA area, all the original MPAs, because he argued that they needed further research to determine whether they really did have the high ecological value that had been provisionally assigned to them. And he has decided that some of those areas that were indeed identified as of high ecological value are going to be removed from the network or phased for protection, not come into force until 2030. And I want to remind the Minister and the Assembly of what was said regarding those further research areas back in 2024 when we debated the Marine Spatial Plan. Because I had my worries at that point about how those further research areas would be assessed. And so I asked a question of the Minister, an oral question of the Minister, to ask him what he would do when that further research came in. And he replied, "We do not have the actual evidence to show that they are, that is, the protected areas are as they described on the maps. I said to officers, I want more evidence. I want you to go out and do the work, provide me with the data that shows that there is something worth protecting there, and I will protect it. So I say to the Deputy, yes, when officers come back, and I know they will come back in short order, and show me that there are merle beds or anything else that needs protecting and there is justification for that protection, I will act and those areas will be protected. I will act and those areas will be protected, he said. And in the debate on the scrutiny panels, because members will recall that, as Deputy Jones has said, the scrutiny panel proposed reintroducing those further research areas on the precautionary principle that we might want to protect them first and then open them up later. The Minister said, again, I propose that we need more research, and we and the department will do this research in the next 12 months, because if there is something to protect, then we will protect it. If there is something to protect, then we will protect it. Now, there has been some extension of the network, but some areas have not been protected, even though they have been identified as of high value. And in particular, some areas have been deferred for protection until 2030, even though they were identified as having high ecological value. And I think that is a matter for enormous regret. I think the problem with delaying some areas of high value until 2030 is it effectively holds out a sign saying, fish here now. You have 4 years until this area is closed. And I questioned the Minister about this as well. Members may recall a few weeks ago. And he conceded that there was indeed a risk that these areas would be fished out with those sensitive areas considerably destroyed before protection arrives. And I regret that too. I read the letter from the fleet with interest, and I very much appreciate them taking the time to write to us, and I do not blame them at all for taking the view that they do. They have livelihoods to protect, and it is entirely natural that they should want some reassurances on those livelihoods. It did make me think of a very long time ago when I did my PhD on the decline of the coal industry and the contrast between Britain and Germany and how the management of the decline of the coal industry was taken. And in Britain, of course, the pits were closed and there was very little account taken of the effect it would have on the coal mining communities, and many of them to this day are still struggling. In Germany, a very different view was taken, that they would manage the change away from coal over a long period, and that they would put in place support measures to help every community that was affected to transition away with a long lead-in time and so on. And I do think that when we think about the fishing industry, the thing that we are missing here is the vision, the strategy. The thing that would give the fishing fleet confidence in a future that included high levels of protection and did mean that they would not be able to access some areas that they had traditionally accessed, but that there was a vision that could see a profitable future in the fishing industry despite that. It would need a comprehensive strategy. In my view, that strategy would be built on the principle of increased areas of marine protection so that they cover all the sensitive ecological areas identified by recent surveys. It would also include, as the Minister is committed to do, which I'm very pleased to hear, catch limits based on scientific assessment of what annual catches are actually sustainable. And that is a really, really important management tool, because the problem we've had up until now is that there have been no limits on the Jersey fleet. Actually, the French fleet is limited in terms of what it can catch, but in terms of the Jersey fleet. And that encourages an entirely rational economic behaviour, which is to get as much as you can, but it doesn't work for the long term. The tragedy of the commons, as I've referred to it before. But crucially, those changes would be balanced by a package of financial measures that would ease the transition into a genuinely sustainable future. And that seems to me to be the missing piece of the puzzle here that we're not talking about. If we are going to ask the fleet to move to a different operating situation, then they need to know that they will be supported through that. And I think for the next government, we might look at how the Rural and Marine Support Scheme could be used to do that. I've spoken before also about the way that we might invest in fish processing facilities that would also help with an on-island, developing an on-island market. So I do think that confidence-building measure is very, very important. But for now, we are debating regulations proposed by the Minister. There is no getting away from the fact that they have been watered down. They were watered down initially by taking out some areas, shifting other areas to further research. They have now been further watered down by some of those further research areas being removed and some others being phased for 2030. The 23.55% that we will reach by 2030 includes 2% that was added to the network, even though those areas were of very limited value as a trade-off for removing some of the other high-value areas. So we are not going to reach 30 by 30 on this trajectory. We're not even going to be close. We're going to be just over 20%. That is a shame. However, we have before us some measures which are undoubtedly a very significant improvement on what went before. I understand that the Minister has had to have detailed discussions with the fleet and with the French about the compromises that he feels are necessary to get sufficient acceptance for these. Any minister, I think, would have had to make some compromises. I am disappointed that the principle of the scientific basis for designation was not stuck to. It seemed to me to offer a line that was worth holding. We've broken that line. It is a shame. But overall, I welcome very much these measures. I think, we all know in our heart of hearts that the long-term future for bottom dredging is not really sustainable. It is bulldozing the forest to get at the mushrooms. And ultimately, we need to find a way to move away from that. We need to do it in a way that supports the fleet. There are sustainable ways of getting scallops. There may be some areas which can be dredged sustainably. I think that is worth looking at as well. But for now, I welcome very much the overall thrust of these regulations, which I think do offer a very significant improvement. Thank you.
Thank you, Deputy. Does anyone else speak on the principles? No one wishes to speak. Yes, Deputy Balash.
So I just would start by saying that I think that Deputy Renouf ought to lose his notes more often. Overfishing obviously leads to disaster, but it seems to me that fishermen are not foolish, and they know that. Sharing of scientific information is important, and if I do have any concerns about these regulations, it is perhaps that information has not been sufficiently shared with the fishermen so that they understand the impact of all the policy decisions that have been made. For my part, I can't really see why complete transparency should not be the general rule. And by that I mean transparency as to thinking processes and provisional conclusions, even if that is characterized as policy under development. Why not? We are all on the same side. We all want a sustainable and profitable fishing industry. So I would like to know from the Minister whether it is a fair criticism that the lack of clarity as to the evidence which has led to wholesale bans rather than more targeted controls over the areas in question. Is that a fair criticism? And if it is, can something be done to make our approaches more transparent than they have been in the past?
Thank you, Deputy. Does anyone else speak on the principles of the regulations? In that case, I call upon the Minister to reply. Minister.
Thank you, sir. And I rise to immediately respond to Deputy Balash. You spoke about overfishing, and he's right, overfishing leading to fish stocks disappearing is a disaster, and the whole idea of a marine spatial plan is to avoid that, and management of our fish stocks is vital, the controlling of the length of the nets, the size of the mesh, the number of pots, the areas that can be fished, all part of trying to make sure we keep enough stock in our sea to keep our fishing fleet profitable and viable. Deputy Balash mentioned provisional conclusions being shared and data maybe not widely shared as much as it could be, but I would refute that. I've met and discussed, and my officers have met and discussed with both sides of the argument all the way through, and Deputy Renouf, and I'll come to his words in a minute, spoke of where we started in 2024, and I would say to members that the reason we've moved away from the area, the larger area first proposed in 2024, is that more data and evidence came forward, and that was reached with discussion. Those changes were reached after presentations and representations, not just from the Jersey Fleet, but from the French government and the French fishing associations. And I have compromised, and changes have been seen over the years, as were referred to by Deputy Renner. So Deputy Renner says we can excel, and we can, and we do. And as I mentioned, we have the best regulated and managed bass fishery in Europe, and we can continue with that in the same vein, sir, and move that to other species. At a meeting in London recently, only a fortnight ago now, I met with representatives for the other Crown dependencies to meet Lords and members of the House of Commons to discuss marine protected area. And the work we're doing here in Jersey was greatly admired and envied by some areas of Britain. Deputy Renner mentioned overfishing, and of course he's right. In certain circumstances we have overfished and almost lost our whelks. Crab and lobster maybe not so much and affected by the change in water temperature, but certainly we may well look back and think, should we have caught less lobster 5 or 6 years ago? The scallop yields at the moment are particularly good, but we do need to keep an eye on them. We're taking more tons of scallops out of the sea than we've ever done before. This year, we are going to do a stock assessment with Bangor University and come up with what we think is a sustainable level of yield of scallops from our sea. But as far as I'm concerned, we're certainly not going to allow anybody to overfish or outfish the scallop stock. Deputy Renner mentioned the further research areas that I asked for evidence for back in 2024, and the evidence was given to me. We did gain more evidence and data on the level of the stock and the value of the stock, and that evidence continued to come in late into last year, even into the beginning of this year, sir, which was the final piece of information I needed to come up with the final designation of these areas. And the things I have had to do to balance out the areas that we've ended up with is to look at the frequency that fishing boats go into these areas, the value of the catch they take out of these areas, do any of these areas provide shelter to the fleet at certain times of the year, the depth of the water. All these things have to be, in my view, balanced. And with that data that was provided to me, I made some changes. Deputy Renner says it's a shame we're not protecting all the areas. Well, they will all be protected eventually, just some may not be protected immediately and some will have to wait. But where I have allowed for certain areas to be continued to be fished until 2030, it's where the data has shown me that there's less value in the protection, and the areas are also heavily fished and used by the fishing fleet for a number of reasons. So closing them to the whole fleet wasn't, in my view, the best thing to do. Yes, there's a case for saying we should have closed the whole area immediately, but to me, sir, that would have had an absolutely detrimental effect on the livelihood of the fleet, and I wasn't prepared to do that. I do accept, and I've said already, that more finance is going to be needed to help the fleet through the next few years, which are going to be the difficult years, because when we get to the point of having a sustainable fishery, they will be able to have to put in less effort to get more out and remain profitable. So there will be some sort of compensation in some form. I said that in my opening speech, and I'm sure the next government will have to address that. Certainly something we are looking at, and I've agreed with the Economic Minister, is that we have put together, and he has funded a future fisheries project, which is just getting underway now, where we very much hope we're going to be able to identify for the fleet ways of adding value to all the products they sell, which means they can catch less and make more money. At the moment, we're sending large tonnages of scallops to Scotland for wholesale prices, bulk prices, and what I'd like the fleet to be doing would be to catch less and add value and take more money for smaller amounts of tonnage. I'll just move now, if I may, quickly, sir, to my Assistant Minister, the Constable of St Bride's, and I'm grateful for his input as ever. He hears the views of the fleet and reports them to me. He mentioned 30 by 30, and I'd just like to say that I've always made the case that it's never my intention that we have to get to 30% of our territorial waters protected by 2030, and I won't protect something which isn't worthy of protection. We will do what needs to be done, but my target is not necessarily to make sure we get to 30 by 30. I would mention, the Constable mentioned Groville and the need to open a CVEP there, and he knows that I've been working hard for a great deal of time to try to make sure that that border inspection post is open again to us. It's been a long haul, and we continue to work on that issue. Finally, so I just come to the chair of the scrutiny panel, and I thank her very much and her panel for their input, for their amendments and the impetus, because without their input, I might not have been given that last for us to get this to the Assembly before the election. It is an important step. It's a very important step as far as I'm concerned. We're moving from 6% to 21% here. We're delivering on a timeline, and while many people may not be happy, the certainty that we're giving with what we're proposing today will at least allow everybody to know exactly where we are. So I've spoken about the future fisheries product. I've spoken about the economic input that we had from the new data that came to me. I just reiterate before closing, sir, that just to say to members, this all the way through has been a balance of looking at the frequency that the amount of time fishing boats spend in particular areas, the value of the catch that they take from those areas, and the economic benefit and the environmental benefit to the idea. So some of the areas that were proposed in 2024 have been upheld. Most of them are still there. Some have been phased, and very few but small areas have been removed. That's all because of the data. That's all because of looking at the research and speaking to people. When we put the higher frequency and the reduced habitat that was to be protected and overlaid them all on charts, it was easy to see where we could make adjustments. Sir, I very much hope members are going to vote in favour of this in the principles debate. The sustainability of the fleet is what's kept me going here, and while they may not all be happy, I think the reductions that we've made in protecting these marine protected areas from the original plan shows that we're compromised, we've listened to all sides, and that this is a really good way for us to move forward from today. Thank you, sir. I call for the appel on the principles.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the chance to cast their votes, I ask the greffier to close the voting. Announce the principles been adopted unanimously. 42 votes for. Deputy Jones, your panel wish to call this in?
No, sir.
Thank you very much. Minister, do you propose the regulations in second reading?
I do, sir. I think I outlined most of the detail in my principal speech, but if members have anything in the second reading, I'm happily answer.
Thank you, Minister. Are the regulations seconded? Does anyone wish to speak on the regulations in second reading? Those in favour of a lot of them kindly show. Thank you very much. The regulations are adopted in second reading. Minister, do you propose the regulations in third reading?
I do, sir. I don't have a speech prepared, but there's two things I want to say. The first one is I'd like to thank Deputy Reniff. He did say in his speech that it was under his ministry that this was started. It's a great piece. The Marine Spatial Plan is a really good document. It's a vital document moving forward, not just for fishing, but for all the other aspects of what happens in and under on our territorial waters. I commend it to members for those who haven't studied it in depth. The other group of people I would wish to thank are my team in Marine Resources Department. We're blessed with some really, really good officers there who do fantastic work. There's been a huge amount of effort for them to get to this point, and I'd like to thank them. And in doing so, I'd like to call for the... you're just...
in a minute.
Yes, mate, I'll stop there.
Thank you, Minister. Is the matter seconded in third reading? Thank you. Does anyone wish to speak on the articles as adopted in third reading? Yes, Constable Bernard.
Just briefly, sir, to emphasise the points made by our colleagues in the gallery who say this is not a call for less protection, it's a call for better decisions taken in the right order so conservation is effective, fair and commands long-term confidence. And I think that's a point we need to listen to, sir. Thank you.
Thank you, Bob. Does anyone else wish to speak in third reading? D'Autelio.
Thanks, sir. I won't speak for long. I have spoken in previous fishing debates, sir. It's simply to say this, that when it comes to measuring the success of what we're passing today, the so-called KPIs, the key performance indicators, are not going to be judged in the next 4 years or in the next 10 years. It will be future generations who will be left with the consequences one way or the other. That will include future fishers who will be hopefully still very active in Jersey waters, and it will be future generations. But I simply note that there are clearly shifting patterns in the oceans and in when it comes to fishing, sir. And so we won't be judging, but those of us who have, any of us who have children and grandchildren, they're likely to decide, reading back on this transcript and looking back over the law, whether the Minister got the right balance between economic and environmental considerations correct in this, sir.
Thank you, Deputy. Does anyone else wish to speak in third reading? Minister.
Thank you, sir. I thank the Deputy Tadier for his words. I'd just say that in response to him and to my Assistant Minister that my door is always open when it comes to speaking to fishermen. I do that on a regular and frequent basis. If they need to contact me, I get back to them. But of course, there is a panel called the Marine Panel, which meets on a very regular basis, where all sections of the fishing community are represented, and we discuss all the issues around the table. I do feel at the moment we have got a good way of moving forward with all these challenges, and I'd like to say to fishermen again, they shouldn't be worried about picking the phone up to me. I think with that, sir, I just commend these amendments to the Assembly and ask them to vote in favour of the third reading. Thank you, sir.
Thank you, Minister. The appeal has been called for. Members are invited to return to their seats. And I ask the greffier to open the voting. Before members have had the chance to cast their votes, I ask the greffier to close the voting. I can announce the regulations have been adopted unanimously in third reading, 40 votes for. Members content to adjourn now? The Assembly is adjourned until 2:15.